William Branson versus Heather Collins, 2402269.
Ready, Your Honor? Good afternoon, Your Honor. I'd like to represent Mr. Branson, who sits to my right.
All right.
Good afternoon.
Good afternoon. And your name, sir, please?
William Branson.
All right, thank you. And counsel?
Good afternoon, Your Honor. My name is Megan Dalbala, appearing on behalf of the defendant. She did request 8:30 in the morning at the last hearing because she works at 11:30. I didn't get notice of adjournment till Friday. I sent a subpoena to a witness on Thursday that I filed with the court. I've been trying to facilitate adjournment, but I have to officially ask the court for that.
Okay, so the court will note that I originally, we were trying to do a date not today, and then counsel was going to be unavailable. And then I picked today's date, and it was my mistake of picking 8:30 because I had already committed to serve as a panelist on a career conference day at Wayne State University. So I was there this morning, and it was my fault that I set that time. So once it was determined that there was a conflict, then communication was sent to your client. It was sent to you once we received your appearance. So that would be why you received that information on Friday, because that's when we received your appearance. And so there was plenty of notice provided to your client where she could have potentially just asked about going into work late, having somebody cover for her for an hour or two, I'm not sure. But before we get to the request for adjournment, did everything occur that was supposed to have occurred regarding the
You ordered it.
let's see here. Number one, I ordered the parties to brief the issue of no certificate of occupancy and collection of rent. Counsel, did you submit yours?
I did, Your Honor. It's titled Memorandum of Law, and the date of filing was 2/14/2025 at 10:45 a.m. I believe both sides have submitted memos, Your Honor.
Somehow it's not showing in here.
I can approach with a copy for the court.
Okay, just one moment. And
Or
then,
we can email it to you now, Your Honor, if you want. Whatever is more convenient.
well, then I also indicated that
An inspection.
there was, yes, counsel, please let me make the record, that the parties were going to meet where Mr. Branson, they would have an independent, they could each have an independent person, so Ms. Branson was not to be present. And there was supposed to be an independent person there with Ms. Collins to go over what the issues were regarding the repairs that need to be made. There was permission to take some photos as well, but they were not to video or photograph each other. So, did that occur? Because I believe that was set for Saturday, the next day, Saturday.
Friday at 5 p.m.
Friday at 5 p.m.
Yes.
That's right, okay.
In fact, it did occur. And what happened is that.
No, I don't know what happened, I just want to know if it occurred.
It occurred with the assistance of the Wyandotte Police Department.
I must state something for the record.
Okay,
Plaintiff was actually, I don't have a copy of a written order and I wasn't here, so I'm at a little bit of a disadvantage, of course.
okay,
Plaintiff, of my understanding, was in violation though because he brought 2 police officers with him. This woman's already being, sexually harassed by her landlord and.
hold on,
Sorry.
hold on a moment.
For safety
Your
reasons.
your client had made allegations regarding various types of harassment or assaults, indicating that those are being investigated. I don't have any information or basis for any of that, so counsel, please, we're not gonna go there.
I'm not trying to bring those claims to this court. I'm trying to explain that under the order and as you described it, there was supposed to be one independent person with each party. She's in significant emotional and mental distress because of her living situation. And then she has her landlord come with 2 police officers instead of an independent person. So plaintiff is in violation of what the court ordered. And it's having a deleterious mental effect on my client who's now being put through the ringer in court that, you know, she's not credible because she's suffering from abuse.
Your Honor,
Well, first of all, I haven't said that your client's not credible.
Yeah.
I haven't said that at all.
Okay, sure. Fair enough.
may I address?
But I also, I will say from an outside perspective, that I don't know that there could be any more independence, as far as independent individuals than the police department, because they don't have any, stake in any of the games.
I appreciate that.
But
And she's
issue.
been made aware of that, but the problem is that it's a very tenuous situation and the court ordered that one independent person come. And that's not what happened. The landlord brought 2 police officers with him. And that was video camera evidence. Even though it's from the police, there's a cam, they wear a
Body
cam.
cam.
Yeah.
Okay, when I said no video, I meant I didn't want each of the parties to video the other party, thereby exacerbating any issues that were going on. That is what this court was intending, because your client was improperly recording the proceedings when she was here last time as well.
I understand.
So I wanted to make sure that neither party was exacerbating any issues or trying to instigate any provocation from the other side. That was why this court ordered no videotaping of the other individual. However, they could take photos of whatever issues needed to be repaired, but they didn't need to have the other person in the video or in the photo.
If I may just,
So my first thought is that if there's 2 police officers there as independent witnesses because they don't have a stake in any of it, I'm not sure how there could be any more independence by that. Did your client have another individual there with her?
honestly, I'm not sure, but she certainly didn't call the police. And if the order said you can have the police present, then I wouldn't even be discussing it. It's not that I'm trying to cause an issue. I need a simple adjournment. I need to get some fairness for my client. And
I'm not saying I'm not going to get the adjournment, counsel, but I'm just trying to understand if any of the things that this court had ordered occurred.
that's hard for me to know precisely.
Well, but I'm also going to say this, that I don't know that there's a violation of the order, of this court's order regarding, and really, I didn't say they had to have an independent person. I said they could each have an independent person. I didn't say that they had to have an independent, I didn't say they had to have anybody there. I said, if you choose to have an independent, a person there with you, right? Because I thought that would probably be most beneficial for both of them. It has to be an independent person. And there are what they call civil standbys, right? So there's individuals that may be going to a property to, if the court ordered they can't return back to the home, they take the police with them to go retrieve some of their personal belongings or what have you. So I don't necessarily know that that's an improper person to have there during the time the photos are being taken. I'm not sure.
Yeah. Guys, Judge, I think the reason she's objecting is because we've submitted the body cam of the police officers. Now, let me back up.
Wait, where did you say? Where did you submit the videos to?
Your Honor, Stewart,
No, Mr. Foley's on Zoom.
No, Mr. Harper.
Okay.
Mr. Harper.
Where did you submit the body cam to?
Your Honor, what we've done is that I've answered her motion.
No, counsel.
It's part of
Where did
it.
you submit the body cam?
It's part of our response to her motion to dismiss. It was emailed.
Who filed the motion to dismiss?
My
Miss-
client filed an amended motion to dismiss.
And so
When did
we,
she file that?
Well, she does not understand the court system or e-filing, so I filed it as an exhibit because a brief was ordered. So my whole position is very convoluted. I have a brief and I have an amended motion to dismiss attached to it.
Your Honor, if I may,
Okay.
the motion was properly filed. It was properly filed, but not timely. You had ruled on that already. So you had a copy of the motion and then.
Well, no. I didn't rule on the motion to dismiss. I say that I wasn't going to hear the motion because it wasn't properly there wasn't proper notice. So I didn't dismiss the motion, I didn't do anything on that. I simply indicated I was not going to hear that on the 11th of February because it had not been properly noticed or hadn't been proper notice. So I didn't rule on the motion. So let me just clarify that for the record. I did not rule on the motion.
That's correct, Your Honor. I wasn't inclining to say to you that you had ruled on anything. I was merely saying to you that when she appeared here in court, they took the motion and they filed it. And I was about to say exactly what you said, so I'm not going to repeat it. But in answer to your question, Your Honor, we had submitted a Dropbox that contains the body cam of the police officer, and it was emailed on Friday at the same time that we filed our responses to D. Peryaski, P-A-R-Y-A-S-K-I.
Oh, yes. Yep.
Yep, at wine.mi.gov. And so the drop link that's there will allow the court to perfectly view the body cam video. And I think, let me tell you why you need to view the
Well, hold
body
on,
cam.
I'm going to tell you why I'm not going to view it right now because it's not properly submitted as an exhibit to a motion. I'm not going to view a video that's just been submitted as a response to a motion or that's been emailed to the court because there's still the evidentiary rules that the court needs to follow, and that's not properly before the court right this moment,
May I address that?
okay?
Like I said before, this was in response to the motion to dismiss. And hopefully you'll take an opportunity, because I know this was filed late on Friday, to review all these documents between now and the next time we return. But in terms of evidentiary, Your Honor, it is not hearsay. It's not an acceptance.
Objection, we shouldn't be going into the details of the video.
I'm not
Sorry.
saying that. All right,
No,
hold
respect.
on, the court's gonna overrule the objection in the fact that, it's a bit premature because there's not been a video offered for evidence at this point. I'm stating that the court's not reviewing the video right this moment that was submitted with your response. I don't even have that loaded on here. Potentially, because it was done late Friday afternoon, and there's, probably 15,000 steps that has to happen from the e-filing once it gets put into here, and Ms. Peryaski is out ill, and so it's not on here. So I want to state for the record, I have not reviewed the video, nor am I going to review it right now, because I haven't had the opportunity to review the response, and there needs to be a review of the foundation before the court can view the video.
I agree with you.
So I'm not going to talk about whether it's excited utterance, whether it's not hearsay or anything of that nature, okay?
In answer to, you had asked when it was filed, and we've answered it. You had asked how it was filed, and we've answered it.
Right.
And then the issue of whether it's admissible or not was raised. I was addressing that specifically.
Right, and I can appreciate that, counsel, but right now is not the time to address the admissibility of it because I'm not hearing the motion right this moment.
I understand that, Judge. All right, so the next item I want to raise is the pragmatic part of this. In our response, we were able to locate the invoice in which my client first went to the city to apply, and it turns out it was in November. So this morning, I had my client go to the city again and request an inspection date.
Objection,
May I finish?
Hold on,
please don't yell at me.
excuse me. I expect that the attorneys are going to address each other respectfully and not yelling at each other.
I would like to finish
So
my
there's really not
statement.
anything to object to at this point, counsel. I'm just listening to what Mr. Dagger has to say.
I didn't get that.
This is the second time that's happened, and Your Honor, I just want to finish
What's the
my
second
statement.
time that's happened?
That she's objected in the
Okay, and I just
sentence.
addressed it, so please continue.
Thank you.
Your client went to the city this morning.
My client went to the city this morning. My client was able to obtain, pardon me, Your Honor, there's a potential witness in the courtroom here who I think is going to be called. And what is your name? I'd like to identify who she is.
No, counsel, I'll find that out.
All right,
I'll find that out. Scott, can you go find out who? Actually, okay, Ms. DeClala, who is this individual?
I don't know. I haven't seen the video. I don't know.
Yeah, counsel, I'm just asking, who's the woman that's here in the courtroom?
Oh, this is, someone who's assisting me.
She's assisting you?
Yes.
So she's not going to be a potential witness
No,
or anything?
no.
Okay, and what is your name, ma'am?
Ariel, I'm a friend of
She's a
Ms.
friend.
Collins.
Okay, you're a friend of Ms. Collins, but you're not intending
No,
to testify?
no.
And so she's helping you out, counsel?
Yeah.
Does she work for you, or she's,
No,
Providing
she's,
information to Ms. Collins.
yeah, and also
I'm
I
sorry,
like,
what?
Filling her in on any facts that she might need because Ms. Collins isn't here.
Okay, well, Ariel, if she's called to testify, won't be allowed to testify then.
I'm not calling her.
No, I understand that, I'm
Yeah.
saying in the future or otherwise, because she's
Yes.
been inside here, so, okay.
But continuing on, Your Honor, as I was saying, my client this morning went to the city and was able to obtain an appointment for next Wednesday between 9 and 2 to conduct all the necessary inspections for the compliance certificate. What I'd like the court to do, if we're going to adjourn this matter, is that I would like an order of the court allowing all necessary inspections to be conducted by the city next Wednesday between 9 and 2 as regularly scheduled. We have no specific control over the exact nature. Now, Sister Counsel had mentioned that there's a statute.
Hold on, before we get to that,
Yes.
we're going to address this.
Mhm.
All right, counsel. I'm not addressing, C of O, no C of O, or collecting rent at this point. I'm just asking, is there an objection to the city on February 25th between the hours of 9 and 2 p.m. to go to the home to inspect the property?
Yes, because they have to get in contact with my client first. In fact, I have from the city of Wyandotte, enforcement details. She submitted to them a copy of her lease. They were requiring that first. And under city ordinance, I unfortunately, I don't have the point, but they have to get in contact with her directly. The city does. I would love to agree to that.
I don't understand what you just said. Do you, Your
The
Honor?
city has to get in contact with Ms. Collins.
Yes.
That's just not true, Your Honor.
Counsel, give me an opportunity, please,
Thank you.
without interrupting.
So this is from BSNA Online, and there's a summary here. There was a complaint, possible rental at the address. The tenant dropped off a copy of the lease and info for request. So now opposing counsel has scheduled the inspection.
Well, no, it doesn't sound as though we scheduled it. It sounds as though the city
Right.
told Mr. Branson when they would be there for the inspection.
Excuse me for misspeaking. It's my impression they have to contact my client in order to schedule it.
And, okay, your state, is there something in the ordinance specifically that says that the tenant has to be present or the homeowner has to be present?
I'm not sure, Your Honor.
May I read the statute, Your Honor?
Okay. You have the ordinance there?
No, Judge, I'm reading the statute she cited to me outside.
No, I'm not talking about the
Well, there is
statute right now.
no such ordinance.
Well,
There is no such ordinance.
hold on. Counsel, Mr. Klala, I'm sorry. You stated that your client is required, that the city has to notify your client.
Yes.
Okay, where is that authority?
I'm not sure.
Okay, but you made that statement, so.
I did, yes. There is a statute, that's a state statute. However, I'm not sure the ordinances. Again, what I was saying before was coming from BSNA Online. But under MCL 125.526, that took effect in February of 2018. It was actually narrowing what could occur during municipal rental inspections. And those are actually exceptions. So they can't go in if it's vacant, they can't go in if it's responding to a tenant complaint, or if the municipal inspector has a warrant for the inspection. So my tenant did complain. This is an inspection that's being scheduled by the plaintiff, which is perfectly acceptable in my eyes, but I don't want to violate the fact that she's due notice under this statute.
Okay, just one moment here.
She's citing,
Hold on, counsel, just one moment. I pulled up 125.526, so please pull it up.
direct your attention to paragraph 7, Your Honor. It's actually paragraph
Hold on,
7.
counsel, just one moment. Except as provided in subsection 7 to 9 and 11, an inspector or team of inspectors must request and receive consent from the lessee to enter before entering a leasehold regulated by this act to undertake an inspection. So we'll read 7, 8, 9, and 11. 7, the owner of a leasehold shall notify the lessee of the enforcing agency's request to inspect a leasehold, shall make a good faith effort to obtain the lessee's consent for an inspection, and if the owner obtains the lessee's consent for an inspection, shall arrange for the inspection by the enforcing agency. 8, the owner of a leasehold shall provide the enforcing agency access to the leasehold for an inspection during reasonable hours if any of the following apply. A, the lease authorizes an enforcing agency inspector to enter the leasehold for an inspection. B, the lessee has made a complaint to the enforcing agency. C, the leasehold is vacant. D, the enforcing agency serves administrative warrant ordering the owner to provide access. E, the lessee is consented to an inspection, or subsection C. If a lessee is not present during the inspection, the enforcing agency may rely on the owner's representation to the enforcing agency that the lessee has consented to the enforcing agency's inspection. So it doesn't appear as though any of these apply. I don't have a copy of the lease that would indicate whether or not the lease authorizes an enforcing agency or the city of Wyandotte inspector to enter the leasehold for an inspection. However, the lessee has made a complaint to the enforcing agency, so that seems to trigger the owner being permitted to provide the enforcing agency access to the leasehold.
That's correct.
That would be 8B.
That's correct.
And then let's see, 9 is the lessee shall provide the enforcing agency access to the leasehold for an inspection during reasonable hours if any of the following apply. And then it's 4 of the previous 5 as well. And then 11, before entering a leasehold regulated by this act, the owner of the leasehold shall request and obtain permission to enter the leasehold. However, in the case of an emergency, including but not limited to fire, flood, or other threat of serious injury or death, the owner may enter any time. So it appears, counsel, that under MCL 125.526, 8B, Mr. Branson has authority to allow access to the home during reasonable hours. And 9 a.m. to 2 p.m. seems as though those are reasonable hours.
Thank you for the clarification.
Yes.
Are you recording, ma'am? Your Honor, I think
Hold on, ma'am, are you recording these proceedings?
No,
Okay, where's your phone?
it's turned off.
Okay, please present it over here for a moment. Okay, here's what I'm gonna ask you to do. I'm sorry, no, hold on, Dave, I'm sorry. Can you please, enter your passcode? You don't have to show your passcode to the court officer, but put it in a spot just so that you're only entering your passcode and nothing else, please.
I have to turn on it first.
It's completely off?
Correct.
Okay. All right, I'm just gonna, so it's completely off?
Correct.
Okay, please hand it to the court officer for a moment. We'll leave it up this way. You'll get it back you'll get it back when we're done.
Oh, wait a minute, no, you can't take my phone from me,
Yeah.
because you're not authorized to take my phone from me.
Yeah.
I'm not like you to me, Brooks.
Yeah,
I would like my phone back.
yeah, all I'm doing is just making sure these proceedings are not being recorded.
Correct, and they're not, but I have not recorded them.
Yeah, I'm just indicating it's gonna be here for just a couple moments,
Oh,
and then you're gonna get it back. I'm not saying it's for hours, no, as soon as we're done with this, you're
oh
gonna
no,
get
I
it
want my
back.
phone back. The
Yeah.
court is not authorized to take my phone.
Yeah,
Under what basis?
because there has been previous recordings.
Not by me.
Can you please not interrupt the court? By Ms. Collins, there is a concern that the proceedings are being recorded. So I'm just trying to alleviate any of the concerns, and it's just gonna temporarily stay right here. That's all I'm saying.
Can you please, under what law that gives the court?
Under the judicial discretion that's given to the courts, under the court rule that allows phones to be brought into the courts.
That you can take my property?
The court has judicial discretion as to whether or not to allow individuals to keep their phones. If you wanna go put it out into your car, you can certainly go do that. It's just not going to be in the courtroom. So here, can you give her back her phone? You can go put it out into your car.
So because I'm friends with Ms. Collins, you're concerned that I will be recording?
No, ma'am, it's not because you're friends with Ms. Collins. There was a concern raised that there's potentially recording. You stated that your phone is off.
It is off, so
Okay.
how could have I been recording if you make it pay? I looked up here, my phone
Ma'am?
is shut off.
Ma'am, this court has judicial discretion to ensure that that there isn't anything improper occurring regarding any recording.
Correct,
Okay.
there isn't.
Ma'am, it has been raised, so all I'm doing for purposes of the proceedings
Right.
is for you to go take the phone out to your vehicle. I'm not arguing with you any further. I've explained the court's position, you can go out to your vehicle,
I will take it up from you.
okay? So, pursuant to MCL 125.526, 8B, the inspection is scheduled for February 25th from 9 AM to 2 PM.
I'm sorry, it's 26, Your Honor.
You said the 25th,
My mistake, I misread it, it's the 26th.
26th,
26, correct, 226.
okay, which I believe your client does not work on Wednesdays. If I recall from last week, I think she.
Thank you for that consideration. You may be more aware than I am.
I could be wrong, because I got
Okay.
the time wrong this morning when I sent the
Yeah.
letter, but I'm pretty sure that she works on the weekends and then on Tuesdays.
And I appreciate your patience.
Yeah, no problem. So, February 26th and from 9 AM to 2 PM. Counsel, when are you back in town?
Judge, I couldn't schedule with my kids, so I'm not going to.
What?
I couldn't schedule with my kids.
What does that mean?
Like, one daughter is finishing Northwestern Law School, she couldn't take the time off to go, so I canceled it. I'm not going out of town.
Oh, okay.
I
Well,
don't wanna go without my kids, so I canceled it.
I was going to have everybody come back, well, I prefer for everybody to come back Friday, because, the inspection itself, I'm not saying it's a moot point, because obviously the property has to be inspected, but for these purposes, I don't know that that has a bearing one way or the other with what this court's ruling regarding the escrow money, because, I believe that the issue that we have left to address is where does the escrowed money get released to whom does it get released? And, Ms. Collins raised a concern regarding overpayment of the utilities. And so there's that issue. So counsel, when the two of you were out in the lobby waiting for the court to call the case, did you go over any of the utilities?
No.
No, Your Honor. Well, we can try to address it before the hearing on Friday.
Okay, I mean, since you're here, you might as well, while you're out in the lobby,
We can.
maybe look at it, or you can
But
maybe
the
go
problem
over to
is-
the offices.
Ms. Collins isn't here, and because she's not here, I haven't been able to get anything directly answered. So I don't know how constructive it would be.
Well, counsel, were you provided any utility bills?
I was, I might need a moment and I might have to do it over the phone because there is some aggression outside in the hallway and I'm not comfortable.
I'm sorry, aggression?
Yes. I don't know how much I'm allowed to disclose because it's settlement negotiations.
I'm sorry.
Okay, all right, your aggression by,
Opposing counsel,
okay, verbally?
physically,
Oh, my Lord.
Okay, what specifically?
he was stepping, the woman Lily who just left the courtroom, you know, even if she shouldn't be involved in the conversation, I respect this, but he was physically stepping in front of her and pushing her back. I witnessed it.
That's not true, Your Honor. That's
It
a
is.
false statement. That is a false statement, Your Honor. We were having a private conversation. This young woman comes up and starts interrupting, getting into my face. So I turned my back, not wanting to confront her, because I didn't want to deal with it. You can see why from earlier what happened. I just don't want to deal with it. It's me and her. She's a very kind human being. I don't see any reason why anybody else can be involved in
Referencing
it.
Mr. Kalala.
I am.
For the record.
Yeah, you know, we've talked on the phone. She's a tenant in the building I built. The guy she works with is my childhood friend.
This is not
Scott.
relevant.
It is very relevant. Finish,
No,
please.
listen.
Ma'am, they're just producing issues for no reason at all. I'm willing to have any conversation with anyone, particularly Mr. Kalala, because I view her as a very kind human being. And I'm not sure where this hostility is coming from, other than the distraction for further noise.
Okay.
And that's something that I'm trying to avoid.
Here's what I'm going to say. So, Miss Ariel or Miss Lily, I'm not sure what her name is, I thought she said
Ariel, I'm sorry, Ariel.
Oh, okay, she really has no point really in participating in the conversation between you and council. But what I'm going to say is we have a court officer that can be near the both of you if, you know, for some more, so that you can feel a bit more comfortable.
Okay.
So we can do that,
If
because
you
I
could
do
be-
think it's imperative that as much as it can occur for council to be in the same room showing the paperwork that's there to be shown on both sides, as opposed to, you know, getting an email or talking on the phone or something like that. So if there was a court officer that's there, would you feel more comfortable with that?
A little bit, but frankly, you know, opposing counsel is a fantastic order, but I'm shaken up. I'm shaken up, you know? I'm not trying to cause a distraction. I can't deal with an overly aggressive person outside of the courtroom, even if it's, you know, when people aren't looking. If it's over the phone, fine. If it's words, fine. I know that Miss Ariel is not my technical assistant. I know that she's not technically involved in any aspect of this case as a party, but I don't feel well internally. That's the problem. And I need to go forward on this motion, this amended motion to dismiss, but I can't tell my client that she can't be here, can't participate. If she's insisting on being here, I have to respect that.
I didn't say she couldn't be here.
Right, and I know you didn't. But what I'm saying is that, to me, it's very clear what the situation is, and that if there's an eviction action, it needs to be done differently.
It's very clear.
Yes, I'm not gonna get into the substance of the matter of the amended motion to dismiss.
Okay,
I don't know what
well,
I
okay,
don't understand what's going on here.
so
And
everybody can be back Friday?
Yes,
ma'am.
what time?
Your Honor, there's just one issue.
Hold on, let me, well, okay, does the issue affect Friday?
It does. Let me tell you why. If the court decides to see the video, we were told by the court clerk that we can't bring with us a stick that you can plug in. But what we've done instead is that we put it into a Dropbox. And I'm hoping, and I brought my assistant Ashley because she's a lot more sophisticated with technology than I am. And so the only reason I've asked for her to be here is to facilitate showing the video if you decide to see it on the screen or multiple screens, however the system works. So that's about the only technical issue that I'm concerned with. I don't know how to do that, Judge. But if you know how to do it.
Your assistant can't be here on Friday?
No, Your Honor, she's going to Florida.
Okay, well, it's just about just make sure she has it saved on your desktop, and that way, when you do your screen sharing, you can access it and pull it on up.
Well, I was gonna ask the court, since we emailed it in a Dropbox to you, would you be able to do it yourself here?
That's not what we do, and I'll tell you why. Number one, and even though it may have come from the police department through the records, it's a way to make sure that we're not getting any viruses into our equipment. So, no, I'm not going to play it on my device.
She just suggested an idea, if I may.
What's that?
She can appear by Zoom if it's possible, and perhaps we can do a screen sharing, and then it can be demonstrated on screen through screen sharing. Is that possible to do?
Yeah, that's fine. I mean, the sole purpose for your assistant is to play the video, correct?
That's right, that's correct.
Okay.
I don't know how to do it, Judge. And in other courts, in circuit courts, we prearrange it. So what happens is that some sort of a cord is plugged from our phone, from the computer to the screen, and it plays on the screen. That's how we've done all the other video. But, you know, when I started.
I don't think there's a cord long enough for, I don't know.
When I started college, Judge, I swear to God, they weren't getting any computers, they were using cards. You know, by the time I graduated, we got into the PC. So I'm not technically savvy. But at the end of the day, Judge.
Change with the times, Mr. Dagger.
Judge, I'm retiring next year. I'm almost 60. I don't really care. And I'm going back to the farm in South Lebanon and raise chickens. Think I'm kidding? It's true. I'm not joking. My grandfather lived to 95 and I intend.
I'm sorry, can we limit the extra comments?
So,
Your Honor, with all due respect, counsel here has demonstrated a great deal of agitation to me, and now I'm in fear.
what are you in fear of, Mr. Dagger?
I'm in fear of being anywhere near counsel and being accused of something. So, I'm just letting you know on the record what I'm now fearing. I'm sorry that I'm a man and that I am who I am.
Gender has nothing to do with that.
But that's what she was suggesting, Your Honor.
No.
Anyway, Judge, we'll be back on Friday, what time is that?
May I request that it's at 8:30?
Let me just double check what the docket is.
Okay.
I'm here all day, I don't have anything I'm presenting, so let me check what the docket is.
We're okay for 8:30 now.
Well, I mean, we'll do 8:30. There may have to be some interruptions where I have to move people in and out of breakout rooms and such, but we'll do 8:30. Everybody can be here at 8:30?
Your Honor, is there a Zoom login information that we can get now?
Yes, just one moment. Well, let me just confirm. I know I just said that there's, okay. So, 8:30 a.m. I'm going to ask that you both email me the briefs that were submitted via my file, just so I can have those to review in the event. I'm not sure when Ms. Perry-Ask is returning. So please email those to review. Please email to me the amended motion to dismiss and your response, Mr. Dagger, plus the video.
Your Honor, I actually did attach the amended motion to dismiss as an exhibit to my brief. Do you want me to do it differently, or is that sufficient?
Did you draft the amended motion to dismiss?
No.
Okay. No, that's fine, it can just stay the way it is. Mr. Dagger, though, I need the response, if you can email the response and just remove the video from the attachment.
We'll do that, Your Honor.
I'm sorry?
We'll do that, Judge. You also wanted the memos, I assume, Your Honor? You asked us to brief?
Yes, so that's what I did, I asked both of you to email the briefs that you submitted.
What's the email address, Your Honor?
27dc@wine.mi.gov.
27dc.
dc@wine.mi.gov.
You should already be copied on an email from me to that email address.
And then the Zoom ID is 656-647-7075.
Is there a password, Your Honor? No password, okay. Can I repeat that to you, Judge, just to be clear? 27dc@WANDOTTE.
Wait, W what?
WAWYO, is it YAN? Yeah, sorry, WYANDOTTMI.
There's an E at the end of the.
TTEMI.gov, correct?
WYANDOTTEMI.gov.
Got it, you got it.
Okay.
And the Zoom is 656-647-7075, correct?
No, 707.
Okay, she's got it.
I got it.
She's the one that needs it, so, okay. All right, and if you have any questions on that, it's on our website as well.
All right, Judge.
Okay.
Thanks again for all your patience.
So Judge, in terms of the inspection, it's not going to be in written form. Do you want us to submit it to you? We can do it now if you want.
Submit what, the communication from
The order of inspection, Your Honor. we can prepare relatively quickly and submit the signature. So that,
Well, you can bring it on Friday, that's fine, because it's still before Tuesday,
yes, we'll do
okay?
that. All right,
All right, anything else?
No.
Okay,
thank you, Judge.
all right, thank you. Have a good day. Let's go off the record for a moment.
I'm not talking.
Utilities on Friday. Please bring all the documentation with you.
May I?
Hold on, let me go back on the record.
Okay, what we can do, Judge, with regards to utilities, I can have my assistant talk to her directly, or we can exchange emails. I won't be part of the conversation. I don't want to be physically in any place near her. So how do you, I'm offering her an opportunity to suggest she can talk to my assistant Ashley, or we can go back and forth in email. I'm not quite sure what would be more efficient.
Well,
In 32 years of practice.
hold on, I'm not gonna get into all the, I'm not getting into all the dissertation. Do you wanna speak to Ashley?
I would speak to anyone, I just, I mentioned he's being physically aggressive and now it's being pushed over onto me somehow.
Who's
So
pushing
I
it
don't-
over on you? I mean, the court's not pushing it over.
I just was no, not the court, opposing counsel, I was just mentioning I can't talk to him outside right now, I need a second to breathe.
I don't
What
want
about,
That's all.
please, hold on, what about speaking with Ashley? You should, and the two of you can go over the utilities and kind of see where you're at. And then Ashley can get her steps in, go back and forth with Mr. Dagger, somewhere where he's somewhere else, and the two of you can have a conversation, you meaning you and Ashley, can have a conversation regarding the utilities.
I have a panic disorder.
Okay,
Yes, I can go sit with Ashley.
okay, all right, so
I'm gonna
Ashley,
stay here.
I'm familiar with everything in the case and I would talk with her this.
okay, and then if there's any
I will go
questions,
back.
whatever, I'm gonna have you go back and forth with Mr. Dagger.
Yes,
But if the two of you have to have a conversation, then when you have the two of you, have that conversation outside the presence of, Ms. Tequila and Mr. Dagger, I'm gonna have you, cause I have some other matters that I'm, handling here, so if you have to have a conversation, then you have to step outside.
What I'll do is I'll sit next to the court officer, Your Honor, near the entrance, and I'll sit there and go back and forth.
That's fine,
I'm
we can open
not
up,
interrupting your court.
we can open up the, either the defense attorney room or the prosecutor room, so the two of you have a desk and you
Okay, thank you.
can. Okay, thank you, we'll see you both we'll see you all on Friday. All right,
Thank you. Better leave first, please.
where would you like to go, I'm sorry. You just wanna go out in the hallway?
Yeah.
Okay.
And Mr. Dagger, when they're discussing, whatever they're discussing, please do not make any comments, okay? At all, don't make any comments, or anything, I'm not suggesting that you will, I'm just,
Judge, I'm a father of two girls,
counsel.
and you have no idea how upset I am.
Counsel, I want everything to go as smoothly as it possibly can, okay?
I think you know how I feel.
Thank you,
Thank you.
okay,
I'll be there.
all right, so off the record. Is going on the record in the matter of William Branson versus Heather Collins, 24022269, and appearance for Mr. Branson.
Good morning, Your Honor. Amy P. 0461 on behalf of Mr. Branson.
Okay, I'm sorry, what'd you say your name was, counsel?
Amy Ducoray.
Duker, okay, I didn't hear the last name, I just heard Amy, okay. All right, and
Good morning,
I
Judge.
did receive your appearance as co-counsel. And I'm sorry, counsel, your appearance,
Okay.
please.
Good morning, Judge. Ali Dagger, also on behalf of Mr. Branson. Your Honor, I asked Ms. Ducray to come in because before she became a lawyer, she was a elementary school teacher and has got a lot of experience with.
Okay, hold on,
Any
hold on, we'll get to that in just a moment, right now I'm just putting everything on the record.
Yes.
All right, and Mr. Branson,
Good morning, Your Honor.
your name for the record, please.
William Branson.
Okay, good morning, okay, and counsel?
Good morning, Your Honor. This is Megan Dalgala. I appear on behalf of the defendant, Heather Collins, today.
Okay, thank you. Good morning, and your name, please, ma'am, for the record, please. Okay, thank you. Okay, so today is the adjourned date for the parties to return. The issues that are, there's a couple things that we are hoping to resolve today. One is the escrowed monies. The other are utilities. And then there are some allegations as well regarding mail as well. The defendant had filed a motion to dismiss. Ms. Collins did improper prior to Ms. Declala submitting her appearance. And let's handle the issue of well, we're also going to address the issue of the order regarding the inspection. I've reviewed the order, I'm not going to sign it as written because this court did not order paragraph 2 that was added into the order. This court, I mean, obviously if there's a violation of an order, there is recourse. But I didn't state in there regarding any interference or third party, so I'm not signing that order as submitted. So that would have to be removed before the court signs it.
Your Honor, can we do that now and resubmit it to you?
What?
We'll do it now and resubmit it to you. Ashley's listening, she's the one that's gonna be.
Okay, that's fine. I'm just saying that, I mean, that's probably can be submitted, I'm just not signing it as currently submitted. The court is also going to address the issue of the I don't wanna call it inspection, but I don't know what I wanna call it. Well, Mr. Branson's ability to look at the property as far as what maybe needed to be done or whatnot, so that was on the 10th, so we'll address that as well. Okay, so, there is an allegation that Mr. Branson cannot proceed because he does not have a valid C of O. Ms. Collins, in her motion, references a specific paragraph that would not allow Mr. Branson to continue. Now, item 7 on the complaint states the plaintiff declares that this residential property was kept fit for the use intended, has been kept in reasonable repair during the term of the lease or license, and is in compliance with the applicable state and local health and safety laws. Okay. Any defects in the statement must be explained below, and then it says the disrepair or violation was caused by the tenant's willful or irresponsible conduct or lack of control. So counsel, I understand that your client filed this, but you also did indicate at the last hearing on Tuesday that you were relying upon the motion. And so what part of that would require this court to dismiss this action?
Your Honor, this action must be dismissed under MCL 125.530. That is the Michigan law that requires a certificate of compliance to be held by a landlord. Under paragraph 5, it states that an action may be maintained where there is not payment into an escrow account, so.
I'm sorry, what was that? An action what?
May be maintained, an action to recover possession of the premises may be maintained where there is not payment into an escrow account. My client has been paying into the court's escrow. I have the register of actions here.
No, I understand. Yes, this court had signed an order of escrow.
Correct, and she is in complete compliance with that. On January 21st, she paid $4,000 into the escrow account as ordered. On January 31st, she paid her monthly rental amount in the amount of $1,500. Of course.
Sorry, just one moment.
Sure.
So you're relying on MCL 125.530, paragraph 3, which you said paragraph 5.
I did say paragraph 5. I'm actually relying on the entire, all the provisions of 125.530.
Okay, so just one moment, please.
Yeah.
So council, you have 125.530 pulled up?
Yeah, yes, Your Honor.
Okay. Okay, so I believe that 125.530 would speak specifically to the issue as to where the monies go from the escrow account.
Your Honor, if I may.
Just one moment, please.
Sure.
Right now, I'm addressing the motion to dismiss portion of it, not the portion that we're going to address regarding the payment of the escrow account. So as to the motion to dismiss, Ms. Declala, what in paragraph 7 would support the request to dismiss this action?
Okay. So I'm referencing 125.530, generally. This was brought up in the defensive responsive pleading and it was relied on quite heavily. It's actually stating that the property can't be legally rented out when it doesn't have a certificate of compliance. You know, that's pretty obvious to us. The issue here is whether an action in eviction can be maintained a summary proceedings in local district court where there is not a valid certificate of compliance. There's certainly not a valid certificate of compliance in this case. We're all aware of that. There's an inspection scheduled with the city in order to correct for that. In particular, I'd like to draw your attention to the court rule for these proceedings. In particular, I'm referencing MCR 4.201 B3C.
Okay, let me pull that up.
Again, that's MCR 4.201 B3C. I'll go ahead and read it.
Hold on, council, just one moment.
Sure.
Complaint specific requirements, 3C. If the tenancy is of residential premises, the complaint must allege the lessor or licensor has performed his or her covenants to keep the premises fit for the use intended in reasonable repair during the term of the lease or license and in compliance with applicable state and local health and safety laws, except when the disrepair or violation has been caused by the tenant's willful or irresponsible conduct or lack of conduct, or the parties to the lease or license have modified those obligations as provided for by statute. Plaintiff must explain any defects in this allegation, for example, local government's failure to inspect despite a request to do so. The relevant scale form must provide space for this explanation. The court may not refuse a filing based on anything in this sub-rule. Okay?
Okay.
So you're relying on the part stating that the plaintiff is not in compliance with applicable state and local health and safety laws?
Correct, and
Okay, so what local health and safety laws are not in compliance?
okay. That would be, the City of Wyandott's ordinance 181.020, no,
Sorry, 181,
0.020.
okay,
No person shall lease, rent, or cause to be occupied a rental dwelling or rental unit unless there's a valid certificate of compliance.
okay. So does that fall under state and local health and safety law?
Yes, it does.
Okay, and how does that fall under there? Because that seems to me to be an ordinance that the city can then enforce against Mr. Branson.
Absolutely, Your Honor. But you know, that's exactly to my point. It's something that the city can enforce, and this is meant to protect the safety of its citizens who are renting out residential units. So it's in direct conflict with the court rule that requires when you file a complaint in these matters for the landlord to represent that the residential property is being kept fit for the intended use.
Okay, so what's in direct conflict, counsel?
Okay, what's in direct conflict is that the certificate of compliance is required to assure the health and safety of the citizen living in the unit. So in order to file a complaint and represent that it was kept fit for residential use, not only is it required under local law for the city of Wyandotte under section 181.02, but also under the court rule for filing these actions, the complaint must allege that the premises is kept fit for the intended use and it's in reasonable repair. So as you mentioned, then it goes on to state in compliance with applicable state and local health and safety laws. Certainly, 181.020 is a local ordinance that's protecting the safety and health of its citizens. That is a local ordinance that's meant to do that.
Okay, and your response, counsel?
Your Honor, my response is severalfold. First of all, the applicable MCR 4.201 sub B, sub 3, sub C clearly states in its express language that that this matter cannot be dismissed for a defect of this section. It says that, it's the last line in here, the court shall not refuse this pleading because this is not complied with. So even if there is a defect in the way that he pled this pleading, that doesn't mean that it should be denied.
Okay, it reads, a court may not refuse a filing based on anything in this sub-rule. So the court has to accept the filing. Okay, so the fact the court has to accept the filing doesn't mean that it cannot be used as a basis to dismiss the matter, but I just wanted to clarify that.
Yes. So that defect is not a fatal defect on as sister counsel claims on the face of the pleadings. That's my argument, Your Honor. Second of all,
I'm sorry, so the defect that your client does not have a certificate of compliance or certificate of occupancy, whichever the title is, I think that it was changed at some point. And so you're stating that that is not a violation of the third part being in compliance with the applicable state and local laws?
it's not a local health and safety law, Your Honor.
Okay.
This is a municipal code under the building code. And if you read section 181.001, where it talks about the certificate of compliance and the purpose of it, a certificate of compliance is issued by the Department of Engineering and Building, which certifies compliance with provisions of codes and ordinances of the city for all rental and dwelling units. There's no mention anywhere in the statute that this should be applied as a health and safety standard. And without actual case law or some citation or some legislative and quasi-legislative intent of the body who enacted this, it doesn't fall within the health and safety laws of this city or the state of Michigan. Moreover, there is a direct statute on point, Your Honor. And that direct statute is the statute that Ms. Aflalo was talking about first. And if we go provision by provision through this statute, Your Honor, you can see that their argument is completely erroneous with the plain language of the statute. And we're talking about section 1.25.530. And if you talk about subsection 5, for instance, it is clear that it says when the certificate of compliance has been suspended or has not been issued and the rentals thereafter withheld are not paid into an escrow account, meaning Ms. Aflalo and defendant are looking at the wrong time period. The defendant did not put monies into an escrow account until she got involved with this court proceeding. She had provided zero evidence or zero proof that there was any escrow account. Moreover, if you continue to read that provision, Your Honor, it says that the escrow account must be managed by the authority with the department with the authority to oversee compliance with the certificate of occupancy, meaning that the defendant would have had to place, at the time she withheld those rents, at the time she decided, I'm gonna withhold the rents because you don't have a certificate of compliance, she would have had to place those monies in escrow with the building department of the city of Wyandotte. And she didn't do that. So she's not in compliance with this statute. And when at the time that this provision was filed, so her complaint now that there's a defect on the pleading that it falls outside the scope of the court rule and that it falls outside the scope of this provision is erroneous, because even if you look specifically at the other provision that Ms. Duckwall stated, which is 1.25530 subsection 3, it says that the duty of to pay rent is suspended, but the monies have to be paid into an escrow account. So defendant comes in here with unclean hands, Your Honor. She comes in here having withheld rent, and the first time she made a complaint is after these proceedings of eviction have started, and it was only after the order of this court that she put her monies in escrow. She cannot now come into this court with unclean hands and try to fix what she did wrong because this court ordered her to do something that she should have done from the beginning. Plaintiff is within his right to bring this action.
Okay.
May I respond?
Just a moment. Okay, so as it relates to not having a certificate of compliance filed with the city, I don't find that the remedy for that is to dismiss this action. So on that point, I'm going to deny the motion. You also allege the property was not kept for tenants' peace and enjoyment required by law. And then also that it was not kept fit for the use intended. And never did finish the kitchen update. So I can't rule on that without taking testimony regarding the intended, whether or not it's been kept fit for the use intended. And whether or not it was kept for your client's peace and enjoyment. So I can't rule on that portion of the motion until I take testimony on those matters. So, okay, now, counsel, your client has stated that the property was not kept fit for the use intended. For example, a bug problem. Okay, so I'm going to swear in Ms. Collins and Mr. Branson. If you can both please rise and raise your hand. Do you both solemnly swear or affirm the testimony about to give this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. So Ms. Collins, or counsel, Ms. Iqbala, your clients raised the issue that the property was not kept fit for its intended use. Okay? She cites, for example, a bug problem. I'm not sure if there was any other problems. Okay, not finishing the kitchen. So other than those two issues, are there any other matters that your client is alleging where the property is not kept fit for its intended use?
May I allow her to speak on it?
Well, first I'm asking you, counsel.
Okay. There's a mold issue in the basement causing significant health issues.
Okay, hold on just one moment. All right, so you're alleging it's causing significant health issues.
Your Honor, my client is asking if she can sit down. She's not feeling well.
Okay,
Thank you.
all right, so let's talk about this. All right, so you're alleging a mold issue in the basement causing significant health issues, a bug problem. The kitchen was not finished.
There is a window in the basement that is almost fully detached from the front wall, allowing, a lot of environmental issues like wind, water, rain.
Hold on, let's see, window and basement. Almost fully detached. From the wall,
Yes,
okay? Okay, what else?
I would like her to continue if it's okay.
Well, counsel, I'm asking you because you're representing her, so I'm
Right.
asking you right now, so what
Okay.
else?
The basement floods. Separate from the window issue. There are certain fixtures within the house, such as vents, that are completely detached from the wall.
Okay, I'm sorry. Fixtures
Yes,
detached from the wall,
yes.
and you said such as vents, anything else or only vents?
There are filters that are broken.
But counsel, I'm still on the fixtures attached from the wall, is it only vents? Is there something else that is attached from the wall?
I'm not sure.
Okay. Ms. Collins, yes or no, is there anything in addition to vents that are detached from the wall?
There
No,
is,
yes or no?
yes,
Okay. What else is detached from the wall?
there is, off the flooring, off the back rail of the steps, there's a metal plate that comes right off. You can just pick it up and fall right through
Is that the wall or the floor?
the floor, excuse me.
Okay, so I asked about the wall.
The
Are there-
vents, all the
Is
vents.
there anything other than the vents that you're alleging are detached from the wall?
No.
Okay. All right, Mr. Clowney, you may continue.
The windows in the basement.
That's already been addressed.
I suppose there may be more than one window with maintenance issues. There is one main window that is almost completely detached from the front.
Okay,
The vents don't close?
Some don't. One room has no heat or air.
okay,
There's one room with no heat or air conditioning.
which room is that?
My mother's room. The front
I'm not sure.
is my mother's room. The one used for my mom.
Okay, I don't know what that
It's
was.
the
First
very-
floor, upstairs, where is it?
Upstairs, very front.
Is there only one room in the upstairs front?
Yes.
Okay,
I'm not sure that's an exhaustive list, but that's what I'm aware of.
okay. Did you send any of this communication over to Mr. Branson's attorney before today?
Oh, there have been
There's also more than just that, yes.
Hold on, ma'am.
There have been many exhibits filed, but the problem is that I have,
So that wasn't my question, counsel.
Mhm.
My question is, did you specify these concerns, the ones that you just stated, I understand it may not be an exhaustive list. Did you specify these concerns with Mr. Branson's attorney? Yes or no?
I did not.
Okay, so counsel, let's, actually, Mr. Cloud, what's the bug problem? Your client alleged in the motion a bug problem.
Yes, she's having to shower with swimsuits on. The bugs are so intense in her shower. I filed quite a bit of exhibits. Contained within those, there's text message evidence that she's asked her landlord several times to fix the bug issue.
Okay, which page of the exhibits are we referencing on that one?
Okay, one second. Your Honor, respectfully, I have a time limitation today. If we're gonna have a full evidentiary hearing, is there any chance to be able to prepare for that? And come back, or, no? There's a lot of exhibits.
This is your client's motion to dismiss, so.
Motion to dismiss, yes.
Right, but one of the
Okay, okay.
elements of that is that your client claimed that it was not kept fit for habitability.
Okay.
So I'm trying to, I said I couldn't, make a ruling on that until I took testimony, so that's what I'm doing.
I don't have a specific page number, but these were filed, and that was on Tuesday. May I approach the bench with,
What was filed on Tuesday?
these are text messages,
On Tuesday those were filed?
yes.
I think that, okay, let me, is there a date on those text messages?
Yes,
Okay, what's the date?
it's June, July, and August.
June, July, and August, okay.
Your Honor, it's the 102nd page of the document that you filed at 8:03 in the morning on Tuesday, just before the last hearing. Page 102, Your Honor.
Okay, I'm not sure if I have that.
There's no base stamp on there, Your Honor, so that's the problem, that's part of the problem.
Well, let me see, so I'm showing, what I have here is January 31st, and our landlord-tenant clerk has unfortunately been out ill. So it's page, okay, but I need to, check to see if Carly, can grab that off and, because I don't see it in my, let me see here. I'm not showing anything here.
Your Honor, it isn't actually, there is a bait stamp on it, there is a document that is, court, like, we have it, it says that it was filed with the court on 2/18/2025. And if I could assist sister counsel, the text message is in that document, so if that's the document that you have, you might have the text message that she's speaking of, and it is on around the 100th page.
I have January 31st, I have a date stamp thing, I don't have that one, so if you, I'll take, let me just let me go off the record for a moment, let me check these people in here, and then let me go jump off and grab that to be printed. Just one moment. In the meantime, Ms. Rawson, we're gonna try to figure out who's here for Mr. Landau.
Okay, thank you.
Okay, Attorney Francis, good morning, which matter are you here on?
Good morning. I am here for portfolio recovery 2400946. 2400946 GC, portfolio recovery.
Okay. Okay, just one moment. All right, good morning, Mr. Katz. Okay. And, all right, you're here on Mills, correct?
Yes.
Okay, Ms. Mills, good morning, or Ms. Tagger, I'm not sure which individual, but I will put the two of you into a breakout room. Let's break
Take
that.
on.
All right, and, Bankstein,
Good morning, Your Honor.
good morning, which matter are you here on?
I'm here on LVNV funding versus Nicholas Saraswolo.
Okay, and what is that case number 230?
02342-GC.
Okay. Okay.
Wilson. 10:30.
Oh. And then crime management, okay. Let's see, I'm checking it out. All right, just one moment. Okay. All right, so let's go back on the record in the matter of William Branson versus Heather Collins, 2402269. And all counsel are present, all parties are present. So the court did step off the bench to grab the exhibit. Is this all exhibit 1?
No, it's exhibits 1 through 9.
Okay, so, and none of these pages are numbered.
Unfortunately, I did not have time and I wanted to submit it before Tuesday's hearing.
Okay,
Your Honor, if I may,
so,
I'm sorry, we just have 2 objections to this, to these.
2 objections to what?
These exhibits, Your Honor.
Okay,
The first objection is the documents were supposed to be turned over in this case by January 31st. And they, on the eve of the last court hearing, produced 105 pages of documents that are not marked. Second of all, if you look through a substantial number of these documents, they reference text messages, which are not the full record of the text message, and they bear no date or time as to when they are sent.
okay, so let me take those one by one. One, the court's going to still allow the exhibits to be submitted because counsel filed her appearance and appeared in these matters after January 31st. So I'm going to give leave for these exhibits to be admitted. Just as though, and there's also been adjourned court dates as well. So as there are other matters that are brought to the attention and exhibits are continuing to be submitted to court, so it's kind of more of a fluid type thing. As the text messages, the objection is noted. I'm going to see if I can voir dire some to try to figure out what it is or not. Where you're talking about the June, July, and August?
Yes, June, July, and August, it's exhibit 5 in terms of the bugs in particular.
Exhibit 5. Okay, exhibit 5. So let's go to exhibit 5. The first one I have is dated Sunday, July 14th at 10:57 a.m.
The first under exhibit 5 that I filed is from Friday, August 2nd.
August 2nd, why would it not start with July 14th?
They are in reverse order.
Okay, well, we're gonna start with Sunday, July 14th, because I would presume that that's the way we need to start. So, the first one says, sorry to text so early, those bugs are back in the tub, I seen them yesterday sprayed what I have and they are still there today, these things don't want to die. What type of bugs are we talking about?
Your Honor, there is a page before that.
Oh, okay, well, okay, that shows August 2nd, I didn't realize that would be attached to exhibit 5, I thought, I missed that part, I thought it was only the title, exhibit 5. Alright, well, I'm not going to review August 2nd until I'm at that date.
That's, so exhibit 5 is actually in reverse order, so the last page, it starts June 18th, and then the one where it says exhibit 5 is in August. It's the last communication. I do apologize
June
to
18th.
the organization.
Okay, well, the back of exhibit 5 for me is September, I don't know, is there an exhibit 6?
Yes.
Oh, there's exhibit 6, so maybe that's exhibit 6. Okay, yep, that's exhibit 6. So, counsel, just for future reference, the exhibit page should not have any exhibits with it.
Okay.
So, okay. All right, so going backwards, Tuesday, June 18th,
Correct.
count at 3:43 PM. Does everybody have that one?
Yes.
And, counsel, if you don't mind, if I just call your attorney Amy, that's a little bit easier to say.
I would prefer that, thank
Okay, thank
you.
you.
My last name is significantly difficult. It's very French for literally no reason at all.
Okay,
I'm trying to get to where you are because I think that when I was going through the exhibits, I may have shuffled them around. But now I think I was looking at, you said Tuesday, June 18th at 3:43?
3:43.
Yes, you're right.
Yes, all right. Also, if you could look, and I'm presuming that the dark background with the light whiting, the light writing is from Ms. Collins, correct? Okay. And then the white background with the dark writing is from Mr. Branson, correct?
Yes.
Is that correct, counsel?
That's my understanding, Your Honor.
Okay. Okay, for Ms. Collins, also, if you could look at these little black spiders, I have all in the bathtub and the bathroom floor tomorrow. When you're here, I'd appreciate it. I tried to clean them out of the bathtub. Mr. Branson's response. Oh, no. Okay, then there's not anything until Thursday, June 27th at 7:49 PM. Okay, was there any communication between the two of you regarding these bugs after June 18th?
Certainly. Yes, ma'am.
Okay, where are those?
I don't know, but we could certainly.
It was just, yeah.
Well, first, if you're asking this court to accept these exhibits, why am I getting partial conversations?
He asked me to take care of them myself.
Okay, that's not my question. Counsel, you've submitted these as exhibit. So this court can view the communication between the parties
Right.
regarding the bugs, and these are an incomplete
Actually,
transcript, so to say, of the text messages.
I don't. He might have not actually responded.
You might just put your phone away unless the judge asks you.
Was there additional communication after June 18th and before June 27th regarding the bugs?
I can't recall.
Mr. Branson,
Yes, ma'am.
okay. Do you have those on your phone?
My phone is in the vehicle because of the situation that's been going on with the phone.
Okay, so that wasn't my question,
Oh,
sir.
I'm sorry,
Do
no,
you have them on your phone?
yes, ma'am.
Your Honor, I'm sorry, I don't mean to interrupt you. I think our administrative assistant has them and she can put them on the screen for you if you like.
I object. I need to be able to review exhibits in advance.
Well, counsel, you've offered the text messages between your client and Mr. Branson as a way for this court to determine whether or not there's an issue of habitability and the property was kept fit for living, and I have partial conversation here. So I need to have the full conversation. So this is new for everybody because, well, your client has everything printed up. Or do you have those printed up, ma'am?
I'm going to look if they're in here. If they're in this file.
Your Honor, she has them and she did.
Counsel,
They might not
I'm-
be in this
I'm-
file.
we're not gonna have any communication right now until we see if these are in here.
Your Honor, I have more complete communications from earlier in July, the 13th and the 14th.
I'm looking for June, between June
I'm
18th
sorry,
and
yes.
June 27th.
Okay. It's July as well. Just looking for between June 18th and June 27th.
All right, we are back on the record in the matter of Branson versus Collins, and so, counsel, did we obtain the other text messages between June 19th, or June 18th and June 27th?
I obtained a more comprehensive view. It's still not clear what the entire conversation is.
Well, here's my question. why am I receiving as exhibits partial conversations?
That's a good question.
Ms. Collins?
Just to show that I sent that there was a bug problem.
No, hold on. But counsel, you've submitted these, right?
Yes,
Did you look at them before you submitted them?
I did, yes.
And did you notice that there is a huge gap between June 18th and June 27th?
Yes, and I was anticipating, laying a foundation and questioning a witness.
Which witness?
Both Mr. Branson and Ms. Collins.
Okay. Did you show Attorney Amy? I'm very elementary when I say that, but I'm very sorry. Have you shown Attorney Amy though that
Not yet,
has a list?
no.
Please show that to Attorney Amy.
Okay, yeah, I won't.
I'd like to take a look at those. I'm not necessarily going to look to read them for any substance, because obviously Attorney Amy has not had a chance to review these. However, I'm trying to, doesn't even have dates on here. January 23rd, oh, that's the date that was screenshotted or something? I don't know what this even means.
In your honor, if I may, just for the record, if you look to the far right-hand column of the thing, that's the first time a date appears, and it appears to be at June 9th.
June 9th, June 10th. There's also Monday, June 10th. Okay, that's not even the relevant time frame.
Your Honor, I can point out the text message where it starts on Tuesday, June 18th, which is separately submitted. Yeah, it's the same text message.
That's not, okay. If text message conversations are going to be proposed for an exhibit, and this court is being requested to rely on the text message conversations to prove something that you're alleging, I need a full and complete conversation, not piecemeal. I'm not accepting those if they're piecemeal. Mr. Branson,
Yes, ma'am.
your testimony is that you have these on your phone.
Yes,
Okay,
yes,
your phone is out in your vehicle?
yes, ma'am,
All right. Please go out to your vehicle to grab your phone.
yes, ma'am.
Thank you. Okay, and so do we have the phone? We're back on the record in the matter of Branson.
Yes, Your Honor, we do have the phone. I'm trying to scroll back to the date. There's a significant amount of text messages between parties.
Okay, so I'm going to ask this. When you get to that point, I'm going to handle one more on the record. When you get to that point, counsel, if you can show Ms. Lala, so if the two of you can go out into the lobby for that so that it's not pulling on the record, okay?
I have to object, because you can go into a phone and line item delete text messages.
Counsel, I'm very aware of that. I just right now want for you, the two of you, to see if those exist and to look at those right there,
Okay,
okay?
okay.
And ma'am, we will then determine whether or not you have any different ones on your phone. We're gonna do this piecemeal, okay? That's how we're gonna do it, step by step.
Your Honor, if I could just make a brief argument regarding this. The defendant is claiming a defense to this eviction proceeding with her motion to dismiss them. She carries the burden of proof in this case to prove what she's saying is true. My client carries no burden to prove her case and defend himself against her case. Defendant came in here today utterly unprepared. And quite frankly, I believe that she came in here with the intent to do trial by ambush by providing intentionally only piecemeal copies of these text message records.
I'm aware as to where the burden lies as far as this motion to dismiss. Right now, I'm not necessarily stating that I'm looking to see the truth of anything within these text messages. Right now, I'm trying to verify something. So please if you will just please humor me and follow this exercise.
Of course, Your Honor.
Okay,
Thank you.
Okay, so, counsel, we're back on the record in the matter of Branson versus Collins. Were you able to view Mr. Branson's phone for the dates between June 18th and June 27th?
Yes,
Okay, and are there text messages between the parties on those dates regarding the funds?
there are several text messages.
Are there any regarding bugs?
Yes,
Okay, now, I'm going to have you all go out there with Ms. Collins's phone, have her turn on her phone, get to that date, and you still have Mr. Branson's phone, correct, Miss Amy?
I did, Your Honor.
Miss Amy, now I feel like I really am.
I actually prefer that. I like attorney Amy to Amy.
And so please take Mr. Branson's phone out with you, counsel. And then you can compare the two phones to see if there's any messages that are not there, okay?
All right, thank you.
very much.
Thank you, okay. Alright, so, Terry, can you read the last time, please? Can you read me the last and couple of the day please? Okay, so we are back on the record in the matter of Branson versus Collins. And so, counsel, you both had an opportunity to review the subsequent text messages after June 27th, correct?
Correct. That is not correct, Your Honor. The defendant walked away and did not allow me to actually look at her phone. She literally walked away from the conversation.
Yes, don't interrupt, please.
And I asked her counsel whether or not there were text messages subsequent to the one that we have on August 18th. We have not been able to, because we have not.
August 18th?
Yeah, so we have a text message specifically on August 18th. Hey, the guy came out, he sprayed, this should take care of it. She says, thank you. That's the last text message my client has related to any book issues.
Alright, okay. Do you have any of those text messages, ma'am?
Yes, ma'am.
Is she allowed to be using her phone at this moment?
As long as she's just looking through her text messages. So, Mr. Klala, did you see on your client's phone the part about the bugs being eradicated and your client saying thank you?
I saw that conversation. I don't consider it proof of any eradication of the
That
bug
wasn't my
issue.
question.
Okay, I saw what you're referring to.
Okay. Did your client allow Attorney Amy to view the text messages that you were viewing?
No, but that was an accident, Your Honor. She walked away. I thought we were just confirming that they both had that text message.
We were, but, well,
Okay.
you were, the two of you were. How is Attorney Amy supposed to do that if your client walked away with her phone?
Okay, yeah, you're absolutely right. I'm sorry.
So the message that somebody came out to spray for the bugs and your client saying thank you, that doesn't mean that those were eradicated.
No, they weren't. There's still a bug issue.
Okay, when did your client then re-notice Mr. Branson regarding the bug issue?
I have to ask her the specific date if she can recall it.
Okay, here's some concern that I have here. Your client is alleging this matter should be dismissed because the home is not habitable, okay? Or it's not fit for living properly. Did you find the text message? Don't stop looking until you find the text message, please. And you've submitted a plethora of text messages that are incomplete. So I should not have to be the one to essentially babysit step by step how the evidence should be brought forth and communicated between counsel. I should not have to do that. But yet, I am having to do that. Because your client has given you partial information. I don't know if you've attempted to get the information from your client and it's not able to be given to you at the time you're asking, I don't know. But to ask this court to dismiss this matter.
They didn't say they were eradicated.
What does it say? Is it right there?
Yes.
Okay, show Ms. Amy what that is. Attorney Amy, the phone.
They said they're harmless.
That's August 18th?
And that's not if you'd like, Your Honor, I'll read the entirety of the text message into the record and they can confirm whether it's accurate or not, if that's.
Is that,
This is August 18th.
Yes.
Did they say they're right?
ma'am,
Did
I'm
they
not
say
asking
they're
for your
wrong?
testimony, I'm asking if you have pulled up the text message
Yes.
that is being referenced regarding
Yes.
somebody coming to spray for the bugs and you saying thank you.
I didn't say thank you, but yes.
Your Honor, the very
Yeah, I
next
did say
sentence.
thank you, you're right, I did say thank you.
Okay, so I'm going to have you follow along on your client's phone. Attorney Amy, please read into the record
Thank you,
the
Your Honor.
date and time and who it's from, please.
Thank you, Your Honor. From Mr. Branson to Ms. Collins on Sunday, August 18th at 2:40 p.m. He identified the bug as a springtail, basically like a gnat. They don't bite, sting, do anything. Totally harmless. They like damp areas. He recommends every time you shower, use the vent. The underside of the tub is totally dry when we ran a camera under it. Sprayed for them. Google springtails. This should take care of them. Hung the mirror and your doorbell also. I ordered some LED lights. It says LED, but I take that to mean LED lights for the basement as well. And untimed response by Ms. Collins. Thank you so much. When you have a moment, can you please show me how to take the doorbell off and I can hook it to the Wi-Fi and app. Sorry I tried and I felt like I was going to break it. Also, the mirror looks great. Thank you so much. I appreciate it. And then there's one response by my client on the sheet that I have that says there's a small orange tool in the box. Use that to unscrew the set screw on the bottom of the doorbell, then slide it up.
Okay. Did you then send, so that sounds to me as though, Mr. Branson fulfilled his obligation at that time as it relates to the bugs. Because he had somebody come out to the home, sprayed for the bugs, determined what type of bug they were, determined that there weren't any leaks because underneath the tub was dry, indicated what type of bug it was, and that it's a bug it's a harmless bug in the sense that there's not any, I presume like a bee or something like that, where it would be stinging or something. And that what type of areas that particular bug likes. Now, did the bugs return?
Yes,
What date?
they've been returning off and on.
No, ma'am, it's your burden.
I don't know the exact date.
Ma'am, it's your burden. You have filed a motion to dismiss and you're alleging that there's bugs and that that's a reason why Mr. Branson should not have checked box number 7. So what other dates have the bugs returned that you communicated that to Mr. Branson?
I can't give you an exact date, so I'm not gonna lie and make one up,
Okay?
if that's what you want me to do.
No, it's not. I don't want you to lie and make one up. Okay, so we'll move on from the bug problem. The kitchen not finished. What's wrong with the kitchen?
When I moved in, I was told that I was gonna be getting a whole brand new kitchen. I was shown their kitchen. When I was walked through to look at it, when I moved in, they said, this is the kitchen you're gonna get. I was given, you're gonna have cabinet doors, brand new flooring, everything. And I said, oh, great. They even said, because there's originally one price on Zillow, they said that it's gonna be $1,500 when you move in because we're doing this kitchen.
Hold on. What was the amount on Zillow that you originally were going to rent the property for?
$1,300.
$1,300 a month.
Yes,
Mr. Branson, is that what the original rental price was $1,300 per month?
it was also on Biddle
Ma'am,
Street.
hold on. I'm talking to Mr. Branson right now.
Honestly, I don't believe so, but I don't have the Zillow thing, my wife puts the Zillow on and.
Okay.
No, the agreed upon with the lease was $1,500. I don't believe it was for 13, I'm not gonna say in
Okay.
confidence because I don't know what the Zillow.
Did you at any point increase the rental price based upon a new kitchen?
Absolutely not.
Okay. Did you take Miss Collins into your home to show her what kitchen she would be receiving?
She's been in our home, but not for that reason,
Okay.
no.
is there a working kitchen in the property,
Oh, absolutely, yes.
Ms. Collins?
Yes. But to be fair, the outlets don't work. For the first 3 months, if I used just one appliance, the entire kitchen wouldn't work.
Okay, did you notify Mr. Branson of that?
Yes, I did. And then December 1st, when I found out one of the outlets was start fire, I let him know.
When did you find out an outlet would start fire?
On December 1st, I went into the hospital and I said, could you fix the outlets? I'm in the hospital, I'm out. He said, okay, I'll go in, you're in the hospital. When I went to try it in November, when I got out of the hospital, I was finally up and I was able to try it on my own. The first time I did on December 1st, I let him know. He rushed over on December 1st, I have it on videotape. He said, well, if it catches on fire, I need to know, and he came into my house, and he was, well, I'm evicting you.
Hold on. If he says if it catches on fire, let me know, doesn't mean that it's an outlet that's going to catch on fire.
No, it's, right, it smokes if I plug something in. So he comes over, cause I said,
Smokes?
yes, I have an
Which
outlet,
outlet are we talking
the
about?
one in my kitchen,
I understand that, ma'am. Which specific outlet?
the one by the back door.
Okay, so, Mr. Branson, the outlet by the back door,
Yes, ma'am.
does it work?
Yes, it works. I mean, she's plugged appliances, there's no evidence of a fire. We have replaced that GFI.
When did you replace the
The
GFI?
first time she complained about it, we replaced and put a brand new GFI.
Okay, what date was that? Okay, what month?
It would have been right after she made the complaint.
I don't know when that was.
I'm sorry, I don't know when her first complaint about the GFI was.
Okay, would it have been summer
No, I
or winter?
believe it was in the fall, actually.
Okay, so before she went into the hospital?
She's
Or
been
while she was in the hospital?
No, she was in the hospital when I did that, yeah.
Okay, all right, so the GFI was replaced. Would you agree with that, Ms. Collins?
While I was in the hospital, correct.
Okay. And then your testimony is that even after it was replaced, it still didn't work,
Correct.
okay? Well, the inspection next week will take care of that. And,
Your Honor, there's a,
and you said that there were 3 other outlets that did not work. Where were those? Where are those?
There's one in the dining room that does not work at all.
Okay, you said the kitchen, there are 3 in the kitchen. Is it an eat-in kitchen? Or is there a separate room for dining room?
There's a separate room in the dining room.
Okay, so we're talking about specifically the kitchen.
Oh, there's another one in the kitchen that, well, the kitchen, if you were to plug one into the other, then the whole kitchen goes out.
Yeah, I don't know what one into the other means. I need you to be specific for the record, okay? And I also am asking you, you said there are 3 outlets that do not work. Where are those 3 outlets located?
There's, well, the 2 right there that I was talking
Ma'am,
about,
okay.
that start,
Hold on. You keep saying right there. I don't know where right there
the
is.
one by the back door.
Okay, there's 2 by the back door?
No, I'm talking, to me, 2 outlets are the 2 plugs right there that are together.
Okay, so it's 1 outlet, 2 plugs,
Correct,
not 2 outlets. Okay, so it's 1 outlet with 2 plugs.
correct.
Is there another location in the kitchen that the outlet with 2 plugs does not work?
No, that one, that's
That's the only
yes,
one?
that I
Okay,
know of.
okay, so what part about the kitchen does not allow for the home to be fit for its intended purpose?
What I was talking about with the kitchen, ma'am, is they baited and switched me with the kitchen. And I have proof of that.
Okay, what's your proof of that?
My proof of that is text over and over, and then in the hospital, they finally said,
Okay, where are those text messages?
can I show you on my phone?
Well, are those included in any of these exhibits? Because we have 105 pages of exhibits, which I'm presuming, since the kitchen is an issue, that there's going to be in here somewhere.
I know, I gave them to her to submit.
While she's looking, if I may, Your Honor, just
Yeah.
a brief
The
argument.
fridge and stove are coming
Hold on,
in.
ma'am, I'm asking you to look for them, not read them right now.
Thank you, Your Honor. Even if what Ms. Collins is saying is true, which we disagree with, it doesn't make the kitchen uninhabitable, it doesn't make the house unlivable to the point where she can evade any form of rent for that. Moreover, every conversation that they had about like possibly remodeling the kitchen was put off because Miss Collins indicated she had cancer. And they didn't wanna go in and do a major construction project while Ms. Collins has cancer. And if you look at the entirety of the text messages, which she did not submit again, that's what you'll see. You'll see that there was a conversation about possibly remodeling the kitchen and it being put off because Ms. Collins had indicated to the Bransons that she had cancer.
Okay, so, yeah, when was there a conversation about remodeling the kitchen?
The remodeling in the kitchen was, they're supposed to be done before I even moved in because I signed the lease May, I believe, 24th. I didn't move in until June 17th. It was supposed to be done before
So
that.
hold on, but I think I saw somewhere that you were dropping things off June second, so you had access to the
Totes
property.
upstairs.
You had access to the property June second, so whether or not you moved in fully after that, I don't know, but you had access to the property before
Just
that.
totes.
I recall from the last time, from 2 times ago, that you made the argument that you were not in there for the full month of June, so you should have an abatement for certain dates of that. You had
June 3rd.
you had access to the property and you moved some items in June second. Whether you moved the rest of them in or not after that, absent some reason that stems from the home not being ready to move in, I don't see that that's a basis to abate any portion or prorate any portion of June. However, the kitchen being remodeled or not being remodeled, when you were told it would be remodeled, if that's what the conversation was, and it wasn't remodeled, I don't find that that would be a basis to find the home not fit for habitability. And was there a discussion to raise the rent after the kitchen was renovated?
No, ma'am, absolutely not. I've never raised the rent. I have no intentions of raising rent.
Okay. Ms. Ekbal, what do you have there?
Exhibit 6 contains text messages about the kitchen.
Okay.
Your Honor's probably not gonna love it because it's the similar format as before.
Well, you're correct. July 24th.
Also, I'm at a little bit of a loss. I thought we were arguing a motion for summary disposition based on the certificate of occupancy. So I was intending to call witnesses for a, evidentiary hearing and cross-examine them and lay a foundation for these exhibits for those underlying issues.
Your Honor, I warned opposing counsel that she was mistaken. I gave her fair warning via email, in writing. I think this court is actually purview to those conversations. I think they have happened in line with the conversations related to the proposed order that Your Honor had the ability to view this morning. And instead of, double checking and crossing her T's and dotting her I's, Ms. Duckwalla came in here unprepared for this hearing after submitting documents that are inappropriate and abjectly in violation of the Michigan court rules and rules of evidence.
Your Honor, I'm a little tired from opposing counsel trying to throw the evidence under the bus and say this, that, or the other thing, when all I'm saying is there's procedure to be followed for a motion for summary disposition based on immunity granted by law compared to a full evidentiary hearing while calling the witness.
What immunity are we speaking of? Because because the court ruled on, in fact, let me pull it up. The court ruled when the parties were first here on the 14th. That Ms. Collins was going to be relocating. She, number one, stated she wanted to relocate. And the court ruled that the plaintiff is entitled to recover possession of the property. What I had ordered the parties to brief was the issue of where the money that's held in escrow is to be released, based upon 2 things. Number one, your client indicating that she didn't have access to the property for the month of June or couldn't move in until June 17th, so she wanted a prorated amount. Also, because your client alleged that the certificate of occupancy plays a role in where that rent money that's been deposited in escrow goes. You subsequently filed an appearance, actually, let me just see something here. That was on the January 14th date. We set this for an in-person trial for February 7th. And that's when the court entered the escrow order as well. Then on February 11th, because I must have gotten removed February 11th. February 11th, the hearing was held. We adjourned for the next hearing to address the issues. June 2024 rent, defendant claiming she overpaid utilities, plaintiff going in all hours of the night, stealing meal and harassment. Also, parties to brief the issue of no certificate of occupancy and collection of rent. Then we moved it to the 18th. I had originally stated the wrong time. And then the parties were here on the 18th, except for Ms. Collins. She was present earlier, even though we noticed everybody that the time was changed. And we adjourned the matter today regarding the escrow money and utilities and the two other issues that the court stated. You also, counsel, at that time, wanted to address your motion, amended motion to dismiss. So that's what we're still on. We're still on the amended motion to dismiss. I started with that because if I'm granting that, then the rest of the matters appear to be moot, as far as that goes. However, so that's where we're at right now. So that is what we're here for. So as it relates to the kitchen, what does that state? What is that? And I will also make a statement regarding the evidence. And counsel, you've submitted evidence that is incomplete. You've submitted these exhibits that are incomplete.
I suppose I was just looking for clarification from the court why, to me, this is a motion for summary disposition under 2.116C7 and C8. It's not an evidentiary hearing, so I have testimony, and to not be able to, take testimony of someone that I'm calling with evidence that I can build a foundation for, it's just procedurally, I can't understand. I do understand that you're allowing, and thank you, allowing to hear argumentation on habitability for the number 7 that was checked. I do understand that and appreciate that.
A motion for summary disposition wasn't filed, so this is not a summary disposition matter. A motion to dismiss was filed by your client. An amended motion to dismiss was filed by your client. You're relying on that motion that was filed and then submitted additional exhibits. So we're back to the kitchen.
Could you do me a favor and give me the court rule for the motion to dismiss?
The court rule?
Yes.
Your client filed the court, I don't know what she filed it under.
I don't think she filed it under any court rule.
Well, then I guess, you're claiming that it's, let's see here, property item 7, that is what she referenced. Or, I'm sorry, item 7, non-payment of rent for residential property, item 7.
I'm just asking for the court rule so I can have some guidance in terms of the motion to dismiss compared to my interpretation of it substantively was more of a motion for summary disposition. So if I could if I had the court rule for the dismissal that we're operating under, maybe I could have more clarity there.
Well, presumably I'm operating under 2.119, which is a motion, and your client filed a motion to dismiss. 2.116 is a motion for a summary disposition, and there has to be a 28-day notice, and there has to be a time for response to be filed, affidavits and all that. This was not filed as a motion for summary disposition. This was not filed that way. So we're proceeding as a motion to dismiss.
I don't believe she filed it in the first place. I filed a brief.
Who filed the motion to dismiss, this handwritten motion? Who filed this motion?
That is an exhibit, it wasn't filed, you had ordered briefs, and she had written that before.
No, this was filed.
Oh, my apologies.
This was filed.
Okay.
Prior to your appearance, counsel, this was filed. Because this is what we did not proceed on February 7th, because there hadn't been sufficient notice to plaintiff.
Okay.
So that is why we are handling it in its entirety now, because now everybody's here, everybody's present, that is what we're doing. So, but if you want to stipulate that the property was habitable and we don't need to have further inquiry regarding item 7, then we can proceed with the next issues, that's fine. Or we can continue to proceed with whether or not the property was kept fit for its intended purpose pursuant to number 7, the complaint for recovery of possession of the property.
Okay, I would like to request a continuance, please. For the reason that I was under the impression we were arguing in terms of the disposition of this case under the law in regard to MCR 4.201 and MCL 125.530. I'd like to re-subpoena the witness that I had subpoenaed for Tuesday's hearing in order to have her present.
Which individual is that?
It is Kelly Roberts. She works for buildings for the city of Wyandotte.
Okay, you subpoenaed her to be here this past Tuesday?
Yeah.
Was she here?
No, she wasn't.
No, she was not. Okay, so what does Ms. Roberts' presence or testimony, what's the relevance regarding the motion to dismiss?
I want to ask her about any former inspections of the property.
That would be as it relates to the money held in escrow as to where that goes. But I don't know that I need her testimony for that, but that I'll defer that for just a moment. What does that have to do with the motion to dismiss?
What it has to do with the motion to dismiss is, again, going back to how this is a little convoluted in my brain, because you have MCR 4.201, which dictates that residential properties have to be kept fit for their intended use and purpose, and habitable as it relates to number 7. Then you have MCL 125.30. So to me, if there's no certificate of compliance, and then on top of it, factually, it's not being kept fit for use, especially with the amount of evidence and the amount of issues. If I have testimony from a city employee stating that there's a history of problems at the residence, or some further information that could push the burden of proof, so I can actually get my client the justice that I'm attempting to get now, that's why I'm asking.
If I may briefly respond to just her oral arguments, if
Okay.
it may please support. First and foremost, my client has been delaying this. Like, this has been pushed out a number of times, like a multitude of times, and we're here today. Client's mistake of what was going on because she misunderstood the nature of summary proceedings as opposed to a summary disposition motion. I don't think it's good grounds to continue to delay this. This court has already ruled that this tenant must leave the property, and now it's about where the money goes. The defendant has the burden of proving whether or not there should be some money released to her or all of the money should be released to her. That's her burden. And she came without evidence. Even the evidence that's in here is not relevant. Moreover, the witness that she was trying to call from the building department as it relates to habitability is not necessary, nor is it relevant, because the past history has nothing to do with what's going on today. And the actual condition of the property as it sits today, Your Honor. So that witness is irrelevant. And the reason that witness didn't show up last time is because sister counsel subpoenaed her incorrectly. A subpoena was submitted to the city via email 3 days before the hearing, when the court rule clearly requires 7-day notice with personal service of a subpoena for a witness to appear. So sister counsel didn't even do that correctly to get her witness here. And she could have, she could have subpoenaed her for today, but she made no effort to do so. And if her claim is that this witness goes to where the money goes, that issue is before the court properly, because even if we're not having the full proceeding today, that issue, the specific issue of where the money goes after this hearing is over and you make a determination of habitability would have happened today pursuant to the defendant's own motion. And it is further clear that the express language of the statute that we're talking about, which is actually, hang on. Which is actually MCL 125.528 or 125.530 subsection 5 dictates where that money goes. And the money is supposed to be held by the city. And the money is supposed to be released to the plaintiff for the purposes of completing repairs due to the express language of that statute. And after whatever's left over, after he has been reimbursed for the repairs, is intended to be released to the landlord. It is clear. The statute is clear and unambiguous in its terms that is what happens with the money that is held in escrow, Your Honor. So that witness would have been more appropriately here for the motion to dismiss, and as it relates to the issues that were brought forth by the defendant in her motion, and she's not here today. And that witness is not relevant to move forward to proceed on the issues of habitability, Your Honor, because that witness has not inspected this property.
I sent an email to the witness as a courtesy. I sent it out, priority mailing, but I was retained 4 days before this was. I'm just a little tired of hearing, I didn't do my job, I didn't do my job, I didn't do my job. When I'm not talking about that. Yes, there's a burden of proof. Yes, there's evidence. I'm talking about being able to fairly get testimony from the witnesses I intend to call and to be able to lay a foundation for my evidence. Because a lot of this is trending into what my client's defenses are. It's not relevant to the motion to dismiss, it's what her defenses are.
Okay, what are your client's defenses?
Well, my client's defenses obviously primarily is that it wasn't fit for use and habitability.
Okay,
It's necessary.
so your client is stating that when this complaint for non-payment was filed on January 3rd, that the property was not in a habitable condition.
Correct.
Okay. So you subpoenaed Ms. Roberts, you're intending to call Ms. Roberts as a witness to address the habitability of the property.
Correct.
Okay. When did she go in to look at the property?
I don't think that she has.
So then how would her testimony be relevant?
Because she's the custodian of records for the buildings department.
Okay. But if she has not looked at the property, how can she determine what issues would affect habitability?
I would be more than happy to talk about what issues affect habitability after the inspection is done that's scheduled on Wednesday. But I'm absolutely insisting that someone from the city provide testimony related to this property.
Okay. Has the property been condemned?
No, Your Honor, it has not.
Okay. So have there been citations issued to Mr. Branson regarding property maintenance violations?
No, Your Honor, it has not.
Has there been any documentation that would suggest that the property in and of itself is not habitable?
No, Your Honor, there hasn't.
Ms. Tequala?
So I have significant evidence from my client. There are several pictures that have been submitted to the court.
Okay, let me clarify. Any of those photos, do those render the premises inhabitable?
Yes, the mold issue.
The mold issue, okay. When did the mold issue begin?
Before I moved in.
Okay, did you look at the property before you moved in?
Yes, and I asked him, he told me it wasn't mold, and he
Okay, did you have a mold test done?
No, I believed him.
Then how do you know that it's mold?
No, I've now since.
Okay, where's the mold test?
I'm getting it back right now, and I'm also.
When did you
getting
have
it
the
home.
mold test completed?
About 3 weeks ago.
Okay,
That's the thing, Your Honor.
which photo is alleging the mold? Let me get to that. Which photo is alleging the mold? Look at the mold.
Judge, may I? I think I can help the court.
What's that?
The photographs provided by the defendant in this case are all black and white. It would be absolutely impossible for you to look at those photographs to make any form of determination.
Oh, is this where Miss Ashley comes in, where she's got color
That's right.
photos that she's gonna screen share?
Not like color photos, but we have the body cam. And we've been able to, the body cam for the police is extremely,
Does the body cam show any of the alleged mold spots?
I believe it
No, I'm not
does.
asking for belief, I want to know, does it?
It does,
It doesn't show any mold spots because no mold spots exist, but it does show the general condition of the area in which this defendant claims there is mold.
Okay, Ms. Miller, I really need for you to please stop talking Collins, while somebody else is talking, because it's affecting the record. Okay, and I'm having a hard time focusing on what's being said, because I'm hearing you talking, I don't know exactly what it is you're saying, but I'm just hearing noise that way. So, where are the photos? So the photos had to come from somewhere, were they on a phone?
No, and I do have color copies. They,
See the color copies, please.
I have black and white here.
Well, then why don't we have the color copies here?
Because I need a continuance, I need more time to adjust my exhibits and to be able to run this effectively.
Well, if there's an allegation of mold, I'm not sure why the color copies weren't brought. Was it on somebody's phone?
No, what?
Your phone?
Yes, okay. I received actual printout pictures, that's why I said no, I wasn't aware of it.
Okay.
when I'm looking at the screen, is Kennedy still available or? Is she?
She's not on here, but I mean, if she wants to zoom back in, I can admit her back in.
We're killing her.
But wait on that, because I'm not sure if I'm going to view the body cam or not, I don't know.
We're killing her vacation trip, I'm sorry. I feel bad for her.
Okay, yeah, I'm just looking for you to pull up the pictures.
They're all in different spots, so I have more, they're in three different
Pull
spots.
up one,
Okay.
pull up one for now.
I'm trying to find the best one. Here's a good one.
Okay, show it to council. Okay, Terry, can you facilitate, please?
There's the black one.
I'm not asking for additional comments, I just want the photo, please. Okay, so this is, looks like, okay, where is this photo taken? What room?
In the basement.
The basement. Okay, is it, this looks like there's brick and then maybe cinder block? Okay, where? Okay, this is on the block itself. Is there anything on the walls? Is there any drywall in the basement?
No, Your Honor.
Yeah,
Yes,
there's drywall as well, yes.
there's drywall. Is there drywall in the
No,
basement, Mr. Branson?
No, it's an unfinished basement.
Okay, ma'am, do you know when I say drywall, I'm not speaking of whether or not there's a wall that's dry. Drywall is it's a material that people put over 2x4s or whatnot to create actual walls in rooms. So, is there any drywall in the basement? No? Is that no?
No.
Okay. All right, well, is there another,
Your Honor, I have a photo that was submitted in the exhibit, so it is black and white. But you can see a significant spot that could either indicate the leaking itself or the mold, which may go hand in hand.
Your Honor, even if it shows either or, but counsel's own statement is an admission and you can't tell what it is. And let me say this.
I'm gonna look for, grab another picture, please, that shows more of the wall itself there, please, and not just a close-up of the spot, please.
And let me say this, Your Honor, my client purchased in the summer, last summer, a dehumidifier for the basement. It's been running full-time, and if there's mold in the basement, let's ask Ms. Collins why she has the basement floor filled with her personal belongings, because everybody knows that if there's mold in an area, the spores will get on your belongings. So she is storing her personal items in a place that she's claiming is filled with black mold. It's inconceivable. It's irreconcilable with her current statements.
Okay, why does your client have a dehumidifier in the basement?
Because Miss Collins had said that it smelled musty. So because it smelled musty, he bought a dehumidifier in the basement, just to appease her, to make the damp smell go out of the basement.
Okay.
Moreover, it's very clear that Miss Collins did not order a mold test until we were well into these proceedings.
Okay, so Ms. Collins, is that, what did you take a screenshot of?
I'm just showing it closer.
No, I didn't ask for it to be
Okay,
closer.
that's fine.
Show the picture that you just pulled up and you took a screenshot of. I don't want the screenshot, I want the
I'm gonna delete
picture.
the screenshot. There you go, right here.
Please show, Terry, please show counsel.
I'm gonna get it so it's not cropped or anything, hold on. There you go.
Your Honor, can we show the historic plan?
Yes, I don't even, what is this a picture of? Where is this picture?
He has, before I moved in, he had, shelves blocking, window. The window I'm saying that's like almost falling off, he has a shelf holding that window
Okay,
in.
this is behind the shelving?
Yeah, that's behind the shelving.
So what part of this are you referencing is the mold? The part of the
Right
bottom?
down, yeah, right, all down by
By the
there.
shelf?
Yeah, he's trying to hide it.
Well,
He has stuff on there, behind there.
Ma'am, hold on. That doesn't necessarily show that that's mold. It shows that it could be dark brick or discolored brick. I don't know that. Can you please show that to Mr. Branson?
He has stuff.
Ma'am, when did you become concerned about the mold that you're alleging?
After I got out of the hospital, and they told me that it could be something in my house.
What could be something in your house?
That gave me my disease.
What disease is that?
That I have this low vitamin thing that my body's not reproducing.
Okay. Okay, well, when did you get out of the hospital the last time when that was stated to you, ma'am?
In October,
Okay.
last week of October.
Okay, and so you ordered the mold test 3 weeks ago?
With my doctors that finally put it to me, I first smelled something when I first moved in and he's like.
Right, that's why I got the dehumidifier.
Yeah, that's why I put it in there.
Okay, right, and that's
But I was
established.
never aware, I was never told until like 3 weeks when I moved in that the basement flooded. He sent me a text, oh, by the way, the basement floods.
Okay, hold on. Does the basement flood, Mr. Branson?
No, ma'am, not at all.
Does the basement flood when there's heavy rains?
Absolutely not.
Has the basement ever flooded?
No, ma'am.
Did you ever tell Ms. Collins that?
May I address?
Did you ever tell Ms. Collins the
No,
basement
no,
floods?
I've never told her the basement floods, because it doesn't. I have an adjoining basement, and I have no flood, never have. I've lived there since 1977, and I've never had a flood in that basement.
Okay, and at what point did Mr. Branson tell you that the basement floods?
Within 3 weeks, it would be nice.
Did the basement flood within those 3 weeks?
The first time it got wet, yes. It was
It
really,
got wet, what does that mean?
the walls got wet and the ground got wet,
Okay, did the ground get wet near where the walls got wet?
yes,
And would that wall be near where the window is, needs repair?
yes.
Okay. So, okay, at any point during any of the heavy rains, did you have water covering the entirety of the floor of your basement?
Not.
Yes or no?
No,
No, okay. So it's quite possible that there's some leaky water from the window, went down the wall and on the floor there, that's possible. Okay,
Your Honor, Exhibit 7 is a screenshot of a text message from July, and it tends to indicate that Mr. Ranson did know of the flooding in the basement.
hold on a moment,
Sure.
exhibit 7,
In fact, Your Honor, it actually says exactly what Mr. Branson said, that the basement is never flooded. But it says, hey, if it's wet down there, let me know, but it's never flooded. Literally, that's what it says. Despite the ill-conceived reference that sister counsel would like you to make.
possible.
There's nothing in
hold
it.
on, I can't even find that yet, hold on, I don't even, oh, there we go, I'm coming close, okay. All right. Sorry for the, okay, Tuesday, July 9th at 10:59 p.m. Sorry for the late text, but with the possible heavy rain, make sure you let me know if you're getting wet tonight or tomorrow. And then Ms. Collins responds, will that be in my room or the basement? Sorry if we just get, and then it cuts off. And then there's nothing else after that.
Yeah, because they,
And then and I will note that there's a handwritten note on here, which there also shouldn't be handwritten notes attached to exhibits that said new basement floods before I moved in with a question mark. So,
and Your Honor, the reason she cropped that is because the next text message chain, which me and both Ms. Zavala were able to view when I was scrolling through my client's phone, clearly states, no, it's never flooded. Like, it literally says that, that's why she cropped it.
did you both review that, Counsel?
I was looking at the bug problem, so honestly, I, probably should have been paying attention more. But-
Okay, well, I mean, your focus on them, that was the
Yeah.
purpose of looking was for the bug problem. Okay, where's that message?
We're pulling it up here. Your Honor, can you give us the date of that again, please?
July 9th.
This is trying to ask because he's going to.
Okay, so, all right, so Counsel, you both looked at this, correct?
Yes, Your Honor.
Yes.
All right, so. Okay, starting Tuesday, July 9th, 10:59 p.m. from Mr. Branson, sorry for the late text, but with the possible heavy rain, make sure you let me know if you're getting wet tonight and tomorrow. Miss Collins, would that be in my room or the basement? Sorry if me just getting home woke either of you. Mr. Branson, basement, we have never had a flood, but it's supposed to get nasty. You didn't wake me, I'm on a call for work, so up all night and I just realized wording and apologized. Miss Collins, never apologize, it shows you're a great landlord on top of things and want the best, also don't want the worst in long term. I will watch out, we have to do laundry anyways, and was unpacking a little to get ready for Sky. Okay, and then they talk about Sky, which I don't think is relevant, since I don't even know who Sky is, but anyway. So, it acknowledges that there's not any flooding, but since there's going to be a lot of rain, he wanted you to look for that, I don't know. But it acknowledges I don't find that there's flooding in the basement. But I still haven't heard any testimony that would support your client's motion to dismiss on number 7. Now, whether or not the monies go to whomever, that's a different story. Okay, you're saying that you didn't have room with heat. You have a room without heat and air conditioning, the upstairs front room.
Again, I'm looking to call a witness and.
As it relates to the heat and air conditioning in the room?
Yes, as it relates to everything,
No, I'm asking specifically about the heat and air conditioning.
also that, specifically that, yes.
Okay.
I requested a continuance because I need to be able to, like I say, lay a foundation and call Ms. Collins, I'd like to call Mr. Branson, I'm trying to subpoena and call someone from the city.
Okay, so counsel, I've heard your request for a continuance, and I'm not likely to grant that right now, because this is now the 4th date that the parties have been back. This is the 3rd date that you've been here.
No,
Didn't you start on the 14th?
No.
Weren't you here on the 14th?
no,
Oh, no, you were not. This is the 2nd day you're here, I'm sorry. So which witness are you intending to call regarding the heat and air conditioning in the upstairs front bedroom?
I'm intending to call Mr. Branson and Ms. Collins.
Okay, well, then call them right now. They've been sworn in under oath.
Okay, but the problem is that I need time to deal with the exhibits. I still need a continuance, Your Honor. It's my 2nd time here. This is in less than a week. So I'm sorry that the plaintiff's procedural history is in whatever state it's in. However, again, whether, you've explained to me it's not a motion for summary disposition, but I can't emphasize enough that number 7 is just not true because it's not in compliance with local laws. That's what I was intending to discuss today. And of course, if, we need to pull the evidence to talk about that, that's fine. But the problem is I still need to be able to give my client a fair trial. And I don't feel I can do that under these circumstances. It would be different if I had been before you for a month, Your Honor. I would understand.
The compliance portion regards applicable state and local health and safety laws. Okay, the ordinance that Mr. Branson may or may not be in compliance with based upon the certificate of compliance or certificate of occupancy is an ordinance, not necessarily something that falls under the health and safety laws. So, the issues that we have to, so I think at this point I'm going to dismiss the motion, I'm going to deny the motion to dismiss because the court doesn't find that the defendant was not being, or the plaintiff was not being truthful when he declared that the residential property was kept fit for the use intended, has been kept in reasonable repair. Reasonable repair doesn't mean 100% in repair during the term of the lease or license and is in compliance with applicable state and local health and safety laws, okay? There hasn't been any condemnation notice put on the home. There hasn't been any other citations that Mr. Branson has received that would call into question the health and safety of the health and safety laws as relates to this property. Now, the other issues I indicated that I was going to address regarding the escrow, where the money goes, there hasn't been any Okay? Are you prepared for that?
No, I'm not. I was prepared to come here and discuss a motion to dismiss based on the fact that there's no certificate of compliance. You know, it's pretty straightforward in a lot of other circumstances.
What's pretty straightforward, counsel?
Like if you're in a locality and they check that there's no certificate of compliance, then it's illegal to rent the property, so the complaint has to be dismissed if it's for non-payment of rent. It has to be treated like someone's squatting. You have to issue a 30-day notice to quit. You have to proceed like this. You can't proceed, and she's paid, so there's
Where's the law that supports that?
Okay.
Where's the law that supports that if Mr. Branson does not have a certificate of occupancy or certificate of compliance, that the tenant then has to be treated as a squatter?
That's not what I mean, Your Honor. What I mean is she's been sued for non-payment of rent. She's all paid up in rent. But if there is an issue where there's not a certificate of compliance, you hold a different opinion, but I've stated over and over again that 7 cannot be complied with. That's why a lot of cities are putting into their ordinances specifically that these an eviction cannot be, a judgment of eviction cannot be issued against a defendant in these cases because of that.
But MCL 125.530 indicates an action can be maintained. So if the state law and the local ordinance are in conflict, which one prevails?
It's silent in the local ordinance, but it does say you cannot rent without a certificate of compliance. It's still an illegal occupancy.
So then that is an issue that Mr. Branson will have to deal with the city of Wyandotte if they choose to issue anything regarding him renting property without a certificate of compliance.
Right.
So how does that fall under violation of a health and safety law?
Okay. I'm a little pulled in 2 different directions. 1 second.
Your Honor, while may I respond to her arguments, Your Honor, if it would?
Just for a moment.
Thank you.
I guess I need clarification. Is it the court's contention that ordinances cannot be health and safety laws?
I didn't say that they could not be health and safety laws. What I'm asking is what is the authority that states that the ordinance, right, and not complying with the ordinance is a violation of the health and safety law? That is what I asked.
There's not an assumption when there's a law written to protect health and safety that that's what it's for.
You're telling me that a certificate of compliance is to protect health and safety?
Absolutely.
Okay, where's the connection for that?
Because a certificate of compliance, a city goes in and does an inspection. A certificate of compliance in this case in particular, because obviously you can have commercial ones, is for residential use. That's to make sure that the tenant is safe and it's up to city code. That is the point. It is absolutely to protect the health and safety. It's absolutely pertinent. It's a health and safety law.
Where is the law that states that the ordinances of a locality that addresses rental properties falls under the health and safety laws of the state of Michigan?
I would like a 5-minute recess to locate a case.
Okay.
Thank you.
We'll have a recess. We'll go off the record. I'm gonna have you go out into the lobby though, so my court officer can have a few minutes of the break.
Hello, Sharon.
Oh, yes.
Thank you.
I'm following.
Consolation, I had just had part of one of those muffins that are in the kitchen. So.
I wasn't hungry until I started smelling
I
all that
wasn't
food.
either. When I saw the muffin, I was like, oh no, it doesn't necessarily go with, I don't think there's much protein there, but. Okay, so. Okay, let's go back on the record in the matter of Branson versus Collins. 24-02269, an appearance for the plaintiff again, please.
Good morning, Your Honor. Good afternoon, Your Honor, Amy DeCoray on behalf of the plaintiff, Mr. Branson.
Okay, thank you.
I'll leave that likewise, Your Honor.
Okay, Mr. Branson,
William Branson, Your Honor.
thank you, counsel.
Good afternoon, this is Megan Duckle on behalf of the defendant.
Heather Collins, right?
Okay, thank you. Okay, and just so you know, there is an individual sitting in the court. She is scheduled to meet with me, on some, mental health something or other, I think, as part of her research class. She's on a mock trial team in the 33rd District Court, so she's not here at any point, regarding anything with this case. I just wanted to state that on the record, okay? All right, so counsel, I did give you an opportunity to, wanted to look up some case law.
Thank you for that. I clearly need to brush up on what I learned in law school. It's the Home Rule City Act. So under the Home Rule City Act, and that's the State of Michigan Act, section 117.3 under mandatory charter provisions.
I'm sorry, it's MCL 117.3?
No, that's the section. Let me look up what the Home Rule City Act citation actually is. Okay, so it is MCL, no, that is correct, it's 117.3. And under that act, if you go under 117.3 and go down to section J, it states the public peace and health and for the safety of persons and property. In providing for the public peace, health, and safety, a city may expend funds or enter into contracts with a private organization, the federal or state government, a county, village, or township, or another city for services considered necessary by the legislative body. Public peace, health, and safety services may include the operation of child guidance and community, okay, it kind of goes on, it's contextual. The purpose of this act, Your Honor, is to state that the body corporate, which would be the city in this case, they are allowed to enact laws in the form of ordinances that protect the public peace, health, safety, and welfare, and carry out the enforcement of that. Now, in terms of a case, I can give you the federal cite, or would you like the Michigan citation? Does it matter?
Well, hold on a moment. So before we get to the case, which the case is going to indicate how the laws apply, you're relying on MCL 117.3 to be the prevailing statute as to show that the not having the proper rental certificate is a violation of the health and safety laws.
Correct, this is an enabling statute. So it's a specific directive by the state of Michigan that what the city is doing is it's enacting laws that are for the purpose of health, safety, and welfare of its citizens, and they're responsible for enforcing those laws as well.
Okay, so under J, which is what you referenced, the public peace and health and for the safety of persons and property, in providing, well, actually, it talks about each city charter shall provide for all of the following. And J is the public peace and health and for the safety of persons and property. Is it, what's your phone doing?
They were on for the text messages.
No, there's only one that should be on, not they. Only one should be on, because only one is what we've been using for text
I text
messages.
messaged my boss to let her know I'm still not coming in yet.
Okay,
I had to work today.
you turned it off?
Yeah, I just turned it on.
Subsection.
So, hold on, counsel. The public peace and health and for the safety of persons and property, providing for the public peace, health, and safety. A city may expend funds or enter into contracts with a private organization, federal or state government, county, village, or township, or another city for services considered necessary by the legislative body. Public peace, health, and safety services may include the operation of child guidance and community mental health clinics, the prevention, counseling, and treatment of developmental disabilities, the prevention of drug abuse, and the counseling and treatment of drug abusers. I'm not seeing anything in here how certifying rental homes falls under health and safety?
Absolutely, Your Honor. There's actually several mentions of health and safety and welfare within this statute. That is merely the first. One moment, please. But the case is certainly informative.
Your Honor, may I make a statutory construction argument?
Just one moment.
Thank you.
Okay. If you go down to section 117.35, it does reference the health and safety of persons living adjacent to land that's been condemned.
Okay, hold on. 0.35.
Yes. And then I'd like to direct the court's attention to the case.
Okay, what's the name of the case? Well, I'm trying to get to 0.35, what's the name of the case?
It's called Saga versus City of Dearborn.
Okay, SABBAGH,
Yep,
okay, is this a published opinion?
it is.
Okay, what's the citation, please?
384, Mish, 510, 1971.
Okay.
So, this case is actually particular.
Hold on, hold on. Before I get to the case, I'm going to give Attorney Amy an opportunity to respond to the statutory portion.
Thank you, Your Honor. While I don't disagree with Sister Counsel that this is an enabling statute, this statute was intended by the state of Michigan to allow for the division of large parcels of land to become cities, states, or cities, townships, counties, and things like that. And it is a provision that allows them to enact statutes or to enact ordinances and codes and then thereby enforce their codes in manners that include, spending money to do it, and also to engage in contracts. But you're absolutely right on point when you pointed out to Sister Counsel that nothing in this statute indicates that this specific ordinance was enacted by this municipality, a quasi-legislative body, because a municipal ordinance is enacted by a quasi-legislative body, quasi-legislative body was intended to be for the general welfare. So this statute says, yes, cities can do these things. They have the ability to organize themselves and to create a government and to run their government and to collect and expend funds for the running of their government. But nothing in this statute is relatively on point to determine whether or not the CFO statute or ordinance is from is part of a health and safety or health and welfare was enacted for health and welfare purposes. And moreover, what you said earlier is actually right on point. When you question Sister Counsel about the interplay between the powers that be here, the state ordinance, which we know is, which we've cited many, many times as 125.530, and the city ordinance. When there's an interplay between a state ordinance that's directly on point in something, the municipality is not at will. And when Sister Counsel talks about this case, it's actually proven in this case that the city is not at will to abrogate that statute. The statute set forth the remedy. The statute did not set a private right in the defendant or in a tenant in this case. So while this statute said, yes, the municipality can do that, nothing in this statute says that that's what this municipality did, or that specific ordinance, the CFO ordinance, falls within the scope of health and safety of this community, Your Honor.
Okay. So just one moment.
Your Honor, I'm sorry if you're sick of hearing it, but I'm not sure how much longer we have to go. I again need to request a continuance. I wasn't anticipating being on the 5th hour, after it was scheduled, that's all. That's the reason. And I have other important business matters that I'm missing.
Okay, Council, when we scheduled this date, nobody said anything about having any time limitations, or else I would have addressed that, at that time.
I didn't think it was reasonable that this would be this long.
So are you stating that it's unreasonable that it's going this long?
Frankly, with the situation in terms of the clear violation where cities are responsible for the public safety, health and welfare, and that involves having proper licensure to collect rent under a lease agreement in a residential property, yes, I think that it should again be dismissed on that basis.
Council, you're making many leaps without having any connections to get you to the other side. Because even under the Michigan Occupational Safety and Health Act, Act 154 of 1974, which is in the chapter 408 chapters, I have yet to see anything that would tell this court that a rental certificate falls under the Safety and Health Act, whether it's Occupational Safety and Health Act, whether it's any health act, anything, any of the chapters within the statutes. I have not seen that connection. I understand your thought process that because a house may not have a rental certificate, that there in and of itself is enough to say that there is a violation of health and safety laws. There's not a connection for that, to show that. The issue regarding whether or not Mr. Branson had a valid rental certificate is an issue that he's going to have to address with the city of Wyandotte if they so choose to pursue that. As it relates to your client and her obligation to pay rent without having a valid certificate of rental, your client isn't even allowed to withhold rent without depositing it into an escrow account. So clearly there is a lot of consideration for these types of situations because there's an entire statute on it in MCL 125.530. And nothing in here indicates that this would rise to the level of violating health and safety law. Okay, clearly municipalities want to make sure that there are any homes that are being rented or anything of that nature, any buildings being rented for multiple purposes, right? They want to make sure that businesses are properly registered. They want to make sure that rental homes are properly registered. They want to make sure they know who owns what property. They want to make sure that if somebody is renting something that things are up to code or what have you, okay? So that doesn't necessarily mean that falls under health and safety law, because I haven't even seen anything in the statutes, because these rental certificates, I believe, are good for 5 years. So within those 5 years, there's not re-inspections to make sure that the homes are still habitable and still complying with health and safety laws. So I don't find that not having a certificate of rental, a rental certificate, falls under the health and safety laws. So you can respectfully disagree with me, and you've stated that you disagree with me, you don't find that it's reasonable, and that's your prerogative, counsel. If you feel as though I've gotten it wrong, you can certainly file an appeal. But this court does not find that there is a basis to dismiss this action pursuant to paragraph 7. Because paragraph 7 states that the home has to be kept that has been kept fit for the use intended, which there hasn't been any testimony that's been not kept for use intended, which was a rental property, which is why the allegation that he doesn't have a rental certificate has been at the forefront, has been kept in reasonable repair during the term of the lease. Okay, I've heard some mention regarding an outlet, possible mold, but there's not anything that was put forth prior to this matter having already occurred. And it says reasonable repair, doesn't say 100% compliant without any repairs needed. And the court, and it also says it is in compliance with the applicable state and local health and safety laws. So this court's interpretation of that provision is the home has not been condemned. There have not been repeated citations issued to Mr. Branson regarding violation of any of the codes or property maintenance or anything of that nature. So for those reasons, I find that the home is in compliance with applicable state and local health and safety laws as far as that goes. Mr. Branson will have to deal with the city of Wyandotte if they so choose to proceed. However, if they do, with not having a rental certificate while he was renting the property and collecting rent. The court will also note that Mr. Branson, there's a check that was written at the beginning of November for an inspection. So we're talking, he moved in the month of June. About a little over 5 months of not having a rental certificate, not having a pending one or whatever prior to requesting an inspection. Now, I don't know what's happened with any of those communications. I'm not sure about any of that. But what was submitted in the exhibit that I reviewed last night was that there was an email and a receipt, or not an email, I think, there was a receipt. And I think that there's also a letter included in one of these exhibits regarding that request. So I'm denying the motion to dismiss. I'm not denying your client or yourself, counsel, a fair opportunity to present evidence. I do not find a connection with the ordinance requiring a rental certificate to fall under state and local health and safety laws. So that's the ruling of the court regarding the dismissal. Motion to dismiss. So that's denied. I don't believe that there's any specific testimony that would alter this court's ruling as it relates to the motion to dismiss, because in this court's opinion, it's a legal analysis as to whether or not the property is in compliance with applicable state and local health and safety laws. But I went through the exhibits that were put forth and the issues that your client raised in a written motion regarding the flooding and the bugs, because that could potentially rise to that level. But based upon the testimony that I heard and the review of the messages that I reviewed, that does not seem to be the case. It appears as though Mr. Branson, when something was brought to his attention, treated it as it needed to be treated, or responded as it needed to be responded to. Now, as it relates to the issue of the June rent, let me do this. We have the June rent. We also have the security deposit, because I believe that your client, which I didn't specify this previously, I didn't make a note of it, but I recall that your client, that there was discussion regarding the security deposit, which I think, as we all know, that we can't do anything with that until after Ms. Collins moves out to determine what, I'm sorry, what?
I'm gonna stay till the end of my lease.
No, that is not what this court ordered.
This is, if you're gonna say that this is habitable and I've been paying my rent the entire time.
First of all, you just interrupted the court as I'm talking. But as I was saying, the court, as we all know, we cannot make a determination regarding the security deposit until after Ms. Collins relocates to see if there's any deductions or what have you. Now, Ms. Collins, you stated yourself that you were moving out. You did not want to stay there.
No.
You did. You stated that on February 7th. or 14th?
No, you took my words and you twisted it, Your Honor.
I did, right?
Yes, you did.
Okay, so what is it you said, ma'am?
I have, Your Honor, this right now is the only place I can stay.
No, what
Right
is it?
now, I just
No, no,
found
no.
out my
That's
cancer's
not what you
back.
said. No, that's not what you said. What is it you
I
said?
am 100% paid up to rent. This is an eviction. If I did not pay my rent, I
Ma'am.
was gonna have to leave. I'm
Ma'am.
staying until my lease is up.
Ma'am,
I
What is
appeal
it?
this.
excuse me,
I'm appealing this.
what is it that you said?
Then I'm gonna stay here.
No.
Yes, I did. I said that day that if you're gonna make me, if you're gonna make me pay, I was going to stay. That's exactly what I said that day.
I asked you if you.
That's exactly what I said.
I asked you if you wanted to keep living there, and you said, no, you don't. You said, I will gladly move out.
No, I did not.
Yes, you did,
No, I
because
did
then
not.
we got onto the discussion as
No.
to the escrow money and who gets the escrow money. Because you said that I need my money back so I can go find a place to live. That is how that conversation went. So. The other issue that we have to address is the escrow money. Any other issues that we need to address?
Not at this time for Your Honor.
Are there any other issues that we need to address, council?
No.
Just those issues?
Yes.
The June rent, oh no, the utilities, we have utilities that we have to address.
Your Honor, is there any way we could resume at another time with the rest of
Yes,
this?
I'm
Oh,
going to pick
okay,
another date, I
okay.
just wanna make sure we're all on the same page.
I'm just trying to get somewhere, okay, yes, the utilities.
Okay, anything else?
I don't think so.
I need a timely manner to figure things out.
Yeah, I'm not telling you you have to leave tomorrow.
Thank you.
I'm not saying that at all. Because I also recall that you say that you've been looking for places to move. So to tell me that I took your words and twisted them, ma'am, is not accurate, okay?
Your Honor, I
So-
think you also requested that she provide to you the names and addresses
I
and
did.
phone numbers of the people that she's contacted.
I will not get that to the court.
I did request that, ma'am, because you stated that you needed a certain amount of money to move out. So I was trying to facilitate some sort of resolution between the parties. That is why I asked you for a list of where and the cost that it would take for you to move there.
I'm looking at the cost right now is roughly between $4,000 to $5,000 to
Okay,
move.
that's why I asked you for something in writing
Yes.
to present to the court. Because
I do.
I have some credibility concerns based upon what's been presented to me and only wanting to give me partial information.
It cost me $5,000 to move here into this
Yeah.
place.
So I did ask for you to submit that information to the court as well.
I will have that next time in front of you, Your Honor. I thought it was unsafe because on YouTube
Miss-
I've been harassed.
What?
With your YouTube, I have been getting emails, I've been getting text messages because you put all my information out there.
I don't put your information out there, ma'am. Okay, so we live stream, right? Courts are live
I
streaming.
did not know that at that time.
Ma'am, it's posted all over, the sign's there, there's a sign out in the lobby, there's a sign on our website. There's plenty of notice that we live stream. We do not, and then we take it down after each of the,
And I
after
would
each of
have
the
never
days.
put my email to you, I would have never given you my email, I would have asked you to do that in private. I would
I don't
have never given
remember-
it to you.
I don't remember giving me your email.
You had me give it to you, and you also had me give you my place of employment, and I would have never given you either of those. I would have never given you those on.
Okay, I don't recall having you provide your email address.
Yes, you did.
Zoom, not in the hearing, but, okay, and I apologize if I did, I don't recall that.
And getting harassed many times at work.
At work,
Work and in my email, yes,
okay,
because of that.
okay, well, ma'am, I am unsure how to rectify that issue. I mean, I would hope that people wouldn't be contacting you. It's not appropriate, in my opinion. So, we're going to have everybody return, we're gonna pick a date. These are the issues that we are going to address. Everybody, I'm expecting to be prepared. I'm also expecting that there is going to be productive communication, conversation, exchange of information, whole information between council.
Hello.
And Ms. Ekwala, I did, and Ms. Council Amy and Mr. Dagger, I did review all of the communications that the court was CC'd on regarding the request for utilities, the refusal to speak to Ms. Kennedy, or respond to Ms. Kennedy because it's unauthorized practice of law. Counsel, she is a paralegal, apparently under the supervision of the attorneys, so there can be communication with that. So Ms. Kennedy, I apologize that we've messed up your vacation day today and we haven't needed the body cam video. I don't know if we'll need it next time, I guess just have it ready to go in the event that we have to talk about it, I don't know. But the court is, let's pick the date.
Your Honor,
Yes,
I was attempting to discuss the utilities issue with Ms. Kennedy outside as per your directive last time,
okay.
and she would not go talk to Mr. Ali Dagger about what I was saying. That's why I said I needed to speak with him. She would not go and communicate what I was speaking.
I'm talking about the email that went.
Right, but it's just a little bit harassing to me, honestly. That's the problem.
Your Honor, the real issue is that there was an email sent out where we asked Ms. Declala for information. It was that email. Ms. Kennedy followed up and said, hey, we needed these things from you. Ms. Declala responded to that email with abject vitriol towards Ms. Kennedy, telling her that she's, like, go get your boss. Like, you're not practiced to law. And then I responded. And
Right,
I said,
I reviewed all of
yeah,
this,
and
yes.
I need this information. And she told me, go get Ali. Like,
I didn't know who you were.
I had a notice of appearance on file, ma'am.
Okay, well, I hadn't seen it.
You were emailed it to my men.
Please stop.
You were emailed my.
I am exhibiting respect.
Okay, she's indicated
I
that
just
she
want it to
sent you.
stop. I just want to focus, I'm sorry. I just want to focus on the issues in the case.
Okay, but I will also say, if there's this much emotion between counsel, it's going to be hard to focus on the facts of the case and the resolution of the case.
Just the bottom line is that we just need what she promised, and that is the evidence to support whatever allegation of overpayment of utilities. It's that simple. And we've been trying since the last time we were in court to obtain that information without any success. I would like the court to designate a specific time where that information can be exchanged. We have provided all of our documentation relating to utilities, but we haven't received anything that would evidence any type of offset.
Okay,
Could we set?
so, counsel, is there anything in the information that you and your client have regarding the utilities? Because I believe your client indicated she's overpaid utilities and she is entitled to a credit.
Why can we not engage in discovery requests between us?
It's a summary proceedings,
You
you know.
know, well, I don't know that I don't know that discovery rules specifically apply, but the court's ordering the parties to exchange information as it relates to utilities. So if your client's indicating that she's overpaid, you can turn your phone off now, ma'am, we don't need any more text messages, so you can turn your phone off.
Looking for dates, so we're gonna go to court.
Okay, so your client has receipts of payments, or what is it that she has that she's indicating supports her claim for overpayment of utilities?
So she has been paying via Zelle,
Okay,
an overall rental amount, I suppose. Because her landlord, the plaintiff here, texts her and tells her how much utilities she has to pay every month.
okay, so here's what I need. Here's what I need, I'm gonna spell it right out. I need from both parties text message communications regarding every utility bill that has been communicated, okay? That's the first thing I need. Then I need, if all the payments are via Zelle, I need proof from your bank, the bank statements that show the Zelle. You can even print up the Zelle, whatever it is, as to where it goes. Show the deduction out of your bank. Mr. Branson will show that it was deposited into his bank, okay? So, anything else that we would need, statements, we need the utility statements, that'd be Mr. Branson would have that.
They've been provided with those, Your Honor.
I'm not saying they haven't been, I'm saying what I need to make a determination on the utilities. Okay, so that is what I need as it relates to utilities. Okay,
Thank you, Joe. When do you want us to come back here? I know, we're all excited to come back.
March 14th. March 14th at 10 a.m.
Thank you for that.
Yeah, the escrow will continue, Your Honor?
Yes, March 14th at 10 a.m. Does everybody,
Yes.
That's fine.
Thank you for giving me that time.
Which day is that on, Your Honor?
it's a Friday.
Your Honor, I work on Fridays.
Ma'am, I can appreciate that, but we have to get this matter resolved. I'm trying to give enough time so that there can be the information, excuse me. I'm trying to give enough time for the information to be retrieved and exchanged.
Yes, Your Honor.
And enough time, if there's any witnesses that need to be subpoenaed, to be subpoenaed.
Yes, Your Honor.
Thank you so much.
Thank you.
So, I would plan to be here for a number of hours,
Okay.
okay?
Yes.
I don't know how many hours that is, but I plan to be here for a number of hours,
Thank you, Your Honor.
okay?
Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you. Oh, I'm sorry, hold on. The court did receive another order for inspection, and, counsel, I'm going to have you both look at it quickly, just so you can see what it is that the court's signing, and that the provision regarding the third-party interference with automatic show causes, that was removed.
February 26th, between 9 and 2. Inspectors of the city of Wyandotte. Full cooperation of defendant.
Who else is gonna be there?
Just the inspector.
Nobody else, just the inspector.
Yeah.
And me.
Yes.
Mr. Branson will not be there.
That doesn't state that.
Well, I don't know if Mr. Branson is required, I don't know.
I will be there.
I would presume Mr. Branson would have to be there because he's the owner of the home.
Yes, ma'am.
And we did go over this last
I
time,
don't want police in my house.
excuse me, we did go over this last time regarding whether or not, Mr. Branson was able to be there, or if you had to be there. And the determination after reviewing the statute is that you don't have to be there, but Mr. Branson has to be there. You obviously have the right to be there, but I'm stating that Mr. Branson would have to be there, he's the owner of the property.
I will not allow police on my property though this time, after what happened last time. I'm putting that on the record.
I don't know what happened last time, I don't know what happened last time, I
Oh,
haven't.
you should see the video.
They asked for my escrow account. They said that I'm in Landlord-Tenant court and they didn't believe what was going on. It was a joke.
I'm sorry, but we have another hearing, I really have to go.
Counsel, I understand, hold on a minute, Miss Collins, just a moment, counsel, I understand that, but I also am trying to prevent what I can foresee happening on Tuesday, Wednesday, what day did we say, the 26th?
That's 26, right?
That's Wednesday.
I would like for, if necessary, for the police to be there.
No.
I think to
I
maintain
would
the.
No.
Please,
I was
Hold on.
pushed aside and told I could not go into any room.
absolutely not.
I have it on my security cameras as well. I was pushed aside and told I couldn't go into any rooms because I was in landlord-tenant court. I had to show them my escrow papers or they weren't gonna believe me.
Absolutely not.
Okay,
Not anything
okay.
that you asked for to happen.
What?
Not anything that you asked for to happen. I said, no, he's supposed to take pictures that I want to. They said, this is a joke.
No, I did not state, but counsel, you don't have to point at me.
No, I'm sorry, I apologize.
I did not say only the pictures that you want, that is not what I said.
No, I know that.
What I said was that Mr. Branson was to take pictures of the areas that you were stating were of concern. That didn't prohibit him, that didn't prohibit him from taking photos of other areas of concern that he had, okay? And that was specifically brought up on the record.
He wouldn't do that. He wouldn't take any pictures I asked him to. And they said they weren't gonna make him.
Ma'am,
It was a joke, and I don't
Yeah.
want police in my house.
ma'am, let me just say this, okay? I cannot predict the future. I cannot predict behavior. What I will say is if a city inspector feels the need to contact the police because there may be a disturbance or there may be some concern
I will
or
be
other.
very nice, but they're not.
Excuse me, please stop interrupting me and we're not done.
Heather.
We're not done, please come back up here. I cannot tell the city inspector they cannot call the police, okay? I cannot tell them that. So what I'm saying is,
He's gonna call them, they won't.
ma'am, Mr. Branson, I cannot, here's what I'm going to say. There's not a need for civil standby during the inspection. There's going to be an independent person there, the inspector. And I expect everybody to be on their most adult, appropriate behavior for the entirety of the inspection. That means not communicating in the ear of the inspector as to what they need to look at or anything of that nature, okay? The inspector knows what their job is that they have when they arrive at the home. There should not be any videotaping, there should not be any video recording, there should not be any audio recording, there should not be any communication at all, other than, hi, how you doing? Welcome to my home, whatever, something simple like that. That is it.
I promise you that, Your Honor, except for my security cameras, correct? Our security cameras out of there.
I don't know what your security cameras, would they go on when people walk in, I don't know what that is.
Okay.
I don't know what that is.
I promise I'll be exactly civil this time, 100%.
If the city inspector feels the need to contact the police for whatever reason, that is their right, that is their prerogative, okay? That is what I'm saying. I'm not prohibiting a third party who's not under the jurisdiction of this court from contacting the police.
Thank you.
Thank you.
Thank you so much.
Thank you. Have a good weekend. We'll see you back on the 14th at 10 a.m.
Sounds good.
Did you hear what she just said?
Wait, hold on.
Hey.
Hold on. Please come back.
Hold on. DiSanto, please come back.
No.
Mr. Danner, what is it you just stated to my court officer?
As I stated, Your Honor, as she was leaving, she called
Who's
me,
she?
Miss Collins called me a name, asshole.
I did not. I swear I did not. 100% I did not.
Well, ma'am, you flipped him off last week.
Okay, so you're gonna believe everything he
No.
has to say?
Ma'am, I said you flipped him off last week.
Okay, and I admitted to it, did I not?
You admitted to it.
Yes,
Okay.
and I am not admitting to this. And I admitted to things I said in the hall. I'm not gonna admit to something I didn't do. I admit to things I do.
Okay, so I'm gonna have Miss Collins and Miss DeQuala for you to please leave.
Thank
Not
you.
saying anything. Thank you, Ms. Kennedy. I'm very sorry about your vacation.
She's on the beach room. She's fine.
Did you see her name was on her camera off so that someone did not have to languish behind with her beautiful screen?
This is not how it works.
Thank you.
Thank you.
Thank you, I appreciate it.
Okay, let's go on the record in the matter of William Branson versus Heather Collins, 2402269. And appearance for the plaintiff, please.
Good morning, Your Honor. Amy Bray, P 80461 on behalf of the plaintiff.
Thank you.
Good morning, Judge Ali Dagger, Greenback, also on behalf of the plaintiff, 47355.
Okay, thank you. And
Good morning, Your
sir-
Honor. William Branson, the plaintiff.
Okay, good morning. And counsel?
Good morning, Your Honor. This is Megan Doggall on behalf of the defendant, P 84205.
Okay, good morning.
Heather Collins.
All right, good morning. Okay, so, I just wanted to state for the record that I was at the VFW for a fish fry last Friday. I did not realize that Ms. Collins was working on Friday. I thought she only worked on Tuesdays. I'm not sure why I thought that. Maybe I thought she only worked during the day. But I happened to notice that she was up at the bar area, which is where you had to put your order in. I did not go up there, and I refrained from going up that way. And so I don't know if she saw me or not, but we for sure didn't have any conversation. Would that be accurate?
That'd be accurate.
Okay, so I just wanted to disclose that for the record, just because I was there for the fish fry.
It's a small town.
Thank you.
It is. Lots of fish fries in the small town, that just happened to be the one that we picked to go to. Okay, so I understand that there has been a resolution.
That's correct, Your Honor. If you'd like, I can read it into the record.
Yes, please.
Okay, so what, the parties had a chance to meet for this morning, and what we decided is that Ms. Collins will vacate the premises no later than March 31st, 2025. Currently, there is $7,000 being held in escrow, and the escrow shall be released as follows. $5,500 of the funds being held in escrow shall be released to the plaintiff, and the remaining $1,500 shall be released to the defendant. We are also agreed that Ms. Collins will pay the March utilities directly to the utility companies on time, and we have provided her with a copy of those invoices. The bills currently, as they stand, are the Wyandotte electric internet bill, which is due March 18th, 2025, in the amount of $154.55, and the DTE bill, which is due March 20, 2025, in the amount of $156.78. It's going to be further held that the plaintiff is going to remain in possession of the security deposit until such time that Ms. Collins completely vacates the premises, and there's a walkthrough to ensure that there's no money owing under the lease agreement for damages or the like. And that should the defendant fail to pay the utilities and leave them for Mr. Branson to pay, any monies owed on the utilities for the March payments will be deducted from the security deposit prior to the release of the remaining funds to Ms. Collins. And that is the sum and substance of what we've agreed to this morning, Your Honor.
Okay, and Ms. Akbala?
We're in agreement.
Okay, so let me just clarify a few things. One, that security deposit is in the amount of $2,000, correct? Or is it $1,500 or $1,750?
$2,000.
$2,000, okay, everyone's in agreement with that?
Yes.
Okay. So then this agreement represents resolution of all of the issues.
That's correct.
The June 2024 rent issue, any other utilities issue, and any other issues that have been raised. And so that would resolve all of the pending matters as it relates to this claim.
That's correct, Your Honor. It's our intent that this be a global resolution of all remaining outstanding matters on this case.
Okay, would that be accurate, counsel?
That's accurate.
Okay, so that needs to be reflected in the order as well. And I understand that you have a computer or something because you typed this all up and emailed it to us, which is fantastic. So I'd like for you to specify the amount of the security deposit, just so that there isn't any question. I'd like for this to be as specific as possible. Also, in the this matter having come before the court. Okay, so this matter having come before this honorable court, comma, upon stipulation of the parties, comma, and the court being otherwise fully advised in the premises, then it says $7,000 is there, so it should probably indicate,
Your Honor, that's a typo, and we sent you an additional copy since you've taken the bench that does not have that $7,000 randomly placed in that sentence.
okay, so I would like it is further ordered, before you start talking about the $5,500, it is further ordered that the $7,000 currently held in escrow, court escrow, shall be dispersed as follows. As follows. And then continue with how you have it spelled out with who's getting that, those funds. And then if we can also have both clients' signatures on there as well. So we can, you don't have to have those electronic signatures, you can just put a space for them to sign with a line, and then when it's printed up, they can physically sign.
Can that be printed up here so that's just?
Absolutely, yes, yes.
The only other thing that I forgot to mention, Your Honor, is that we need a forwarding address. Or when you want it, we can send it to Ms. Tekola, in the alternate, however she wants, for the earnest money for the deposit. For the
Okay. Mr. Clava, how would you like that to be handled? Do you want it to be sent to your office? Or do you want it to be sent to the forwarding address for your client?
You may send it to my office.
Okay, and in fact, we would need that information as well, because we're the one the court's gonna be dispersing those funds appropriately.
Like the 1,500 goes to you, or you pick it up here?
This is a forwarding address for the disbursement of the amount in escrow, correct? Or are we talking about the security deposit or both?
Well, both, so we'll need it for both.
Okay.
So the court will need to know where we're going to be sending it,
Oh, $1,500.
the $1,500. You can't just go right to the window today and get that money. We have to process it through, and then we issue a check, we send a check.
When would how long does that take, and when would I be able to get that?
Well, I don't know the answer to that. I will find out for you when I go grab the order. I will find out for you.
Cause if I could get that while I'm still, before the end of March, then that would just be at the address I'm at right now.
I'm pretty sure it'd be before the end of March, but let me confirm that, so I'm not giving you wrong information.
Cause that would be just where I'm at right now, my address, my present address.
Okay.
Yeah.
Okay. And then for the security deposit, the balance of the security deposit, that would be going to Mr. Clava's office. Okay. Any other issues that were forgotten about?
You want that to be reflected in the order, Your Honor, or just, since it's on the record, we're good?
It should be in the order.
This is why she's so good, Judge, we bring her over this.
So while I'm waiting for that to come through, well, before you send that, let me just clarify a couple things. So there was an inspection done, and there are, because the court's been CC'd on all the email, well, at least on some of the emails that have gone back and forth between council. There was an email that was sent out regarding accessing the property to have certain items repaired that are required to be repaired. So is the intention to now delay that until Ms. Collins vacates the property March 31st?
Yes, Your Honor.
That's the best scenario for all.
Yes.
Okay. So let's put that in there as well, that Mr. Branson is deferring commencement of items needing to be corrected per the inspection until after March 31st, when Ms. Collins vacates the property.
Your Honor, my client is requesting that she may be able to sit. She's feeling faint.
Oh, that's fine. You can all have a seat, that's fine.
Is there anything else, Your Honor, that you'd like us to add to the order this time?
I believe that covers all of it. Let me just confirm something here.
Judge, I just want to add for the record that the city conducted an whole test of the area in the basement and it came out negative. I was just placing that on the record.
Okay, thank you.
My client is disputing this, I'm not sure. Just trying to close out the case here. But since we're on the record.
Okay, Mr. Gagger, do you have something that confirms that result from the city?
He was just told, my client was told, but you know what, Judge?
I don't think that, I mean,
It's not, none of this is relevant, it's just, I was just placing it on the record, but
Okay.
she corrected her record, so none of this is really relevant.
Okay, so the issues that were still outstanding were the June 2024 rent, security deposit, escrow money, utilities, and the February 26th inspection. That all appears to be included in this stipulated order, correct?
Correct.
Yes, Your Honor.
I think there needs to be a title other than stipulated order.
Would you like final order?
We could say like maybe order resolving
It could say consent order, consent order resolving.
All claims.
You wanted to identify your last order that just came out, I think on March 11th, that identified the specific issues that were supposed to be before this meeting.
Yes. I don't believe you have to include the inspection portion because that's already concluded, so I don't think that that needs to be included here. But if you want to reference you can just indicate rent, security deposit, escrow money, utilities. Would that be sufficient, counsel?
Yes.
Okay.
You want us to say, so right now we have it as consent order resolving rent, utility, security deposit, and escrow. Do you want us to say as identified in this court's order of March 11th?
No, that's okay, because those were the outstanding issues that we needed to resolve, so that doesn't have to, the date of the order doesn't have to be reflected.
Yep.
And that's authorization for that.
Okay.
So one question, I just want to make sure that we're just tying up all loose ends and not intending to create any other issues. However, regarding the utilities, where it says it is further ordered, should defendant fail to pay the utilities, that amount should be deducted from the security deposit. Is there a late fee in the event utilities are not paid timely?
That would be to the city, not to me, so I don't know.
I understand that, but if you end up paying the utilities, if they're not paid.
We'll waive those, you know.
Yeah, no, I understand, yeah, no, ma'am. No.
Okay, all right, so let's indicate, let's pause on that for a moment. If you indicate in that further order regarding if should defendant fail to pay the utilities, if you would please put it there by March 31st. That way there's a cutoff date. Because if she doesn't pay it and she's paying it April 2nd, and you don't know that, I think that March 31st would be a clear cutoff date, separation date, since that's the date we're already utilizing anyway.
Your Honor, we had modified the order slightly where it says it is further ordered the defendant is required to pay the March utilities directly to the utility companies on or before their due date, which includes the line, and then it goes through. So maybe in that last portion, we can say, like the portion you were just speaking of, we can say, if they're not, he's willing to waive whatever late penalty it is, it's like
Right.
20% or whatever. Just say, to make it more specific, we can say if they're not paid, if the amount's paid, like referencing the paragraph above, so that everybody knows exactly what amounts are supposed to be paid, so that way you know how much money is gonna be deducted from the security deposit, if that would please make it
Okay,
more.
so you're talking about moving that paragraph up
Yeah,
to be right below the paragraph referencing the utilities.
yes, Your Honor.
It should also indicate if the defendant should fail to pay the utilities by March 31st.
Yes, okay,
That way there's just a clear cutoff date, that way your client knows if he's paying those
okay.
or not, and then when those, if those are getting deducted from the security deposit. Would you agree with that, Ms. Teclalo?
Yes.
Ms. Collins, okay. Again, I'm not trying to complicate things further, I just would like to just have everything as clear as it can possibly be. And then if you can, when you're done with preparing that, if you can please show Mr. Glalo before you send it for email, just so she can go through everything as well.
Just be aware of how much time you're asking for these again. The DT is doing much time. Okay. Okay, so.
I think that is a little confusing.
That is confusing.
Because we have the due dates that she's supposed to pay by the.
Yeah, but I think what the court is referencing in that paragraph, if I may, and I don't wanna speak for the court, but if I may, because if she doesn't pay them on time, but she also doesn't pay them before she leaves, I don't think the court wants to have us back saying, with somebody saying, well, I was gonna pay them on April 5th.
Correct.
Yeah,
Correct.
thank you.
So that's so that in the event those are not paid by March 31st, then those amounts are going to be deducted from the security deposit. I just want everybody to know what that last drop dead date is to make those payments before they're deducted. Okay. Yes.
All right. All good?
All good.
Okay. Thank you.
Okay, so if you can please send that to the 27th District Court email, please. And then, right, I'll go run and grab it. I can use, Terry, I'll go, oh, okay, that's fine, okay. Go ahead.
Okay.
That's fine. How can I get this out then? Yeah.
That's why I'm standing here, I'm driving to pick my mother up to come live with me permanently now, but I have to have like 4.5 hours as soon as I leave here, so I'm trying to like at least get my blood flowing before I go sit in the car.
I have one of those stand-up desks that I like to stand up with, but my current setup with all these computers doesn't really allow for that very well.
Have you ever been in Hazel Park District Court?
I don't think so.
Okay, so there, the judge sits literally 6.5 feet in the air, I'm not exaggerating. Like their bench is like starts, like where yours stops, that's where the bottom of their bench starts. And then they had I was in there for traffic court before I went into a different area of law. And the judge would stand up in there and it was like he was like looming over the entire courtroom. It is the most bizarre thing, but it's a very interesting courtroom to be in. Yeah, but he'd like to stand. on his pedestal, apparently.
Judge Kirsten likes to stand a lot too before he retired in 33rd.
Yeah.
And, yeah, sitting all day is one of the worst things.
Yeah, I want one of those ones.
Yeah. I have one in my house.
Yeah, I want one.
I have one in my house. They're so versatile, and then you never one of those walking things, right? It's so small. I always sell one. You're like, I don't know.
Okay, so that should be
I sent it.
coming right back, for everybody to sign as well. Unless, council, did you do your electronic signatures?
I did. Sorry, I did do an electronic signature for the attorneys, yes,
Okay.
but left a spot for the clients.
Okay, thank you.
I know.
I didn't write that down.
Okay, so you can give that over to, we'll have Mr. Cloud and Ms. Helms look at that first and sign it. And Mr. Cates, is Haley Malk, have you heard from Miss Malk? No.
You're not 31st. You can't be on 31st.
Yeah.
That's the argument. What they say. Due dates, he said, but they do have to be paid by March 31st regardless.
Okay.
You gotta do it.
Yes.
And that's saying that, after having paid, promise us and promise and then have to, provide because that's, I think it's like a thing, because, you know, we're saying, no, it wasn't done with the case. So, there's a deferment of the necessary repairs until after you.
Oh, okay.
And listen, really.
It's really fast.
Why are they putting necessary repairs?
Because they don't want to, while you're trying to make it.
Okay, not the, because I haven't done anything to repair, they're talking about the city stuff. Okay, for the city. Alright.
So if I go.
Yeah.
So you just have to sign here. If you don't have to sign this.
What's it? Yes. I'm getting in the next one.
So we went to a whole meeting. We were all mad at you, and we could see your Florida in the background. Thank you.
Okay. So I'm going to sign it and that's going to make it officially official. And then council, if I can see all of you in chambers, please.
Thank you, Your Honor.
We're gonna make copies of the order as well, so everybody will leave with the orders today,
Thank you, Your Honor.
okay? 1, 2, 3, 4, 5 copies, please. So that means, all the attorneys get a copy and then each party gets a copy.
I don't need my own copy, Your Honor. I work for Mr. Dyer's firm.
Okay, so.
Let's save it for you today.
Yes, okay, so we're gonna go off the record for a moment and then